Adjournment request, if any, from item number 1 to 5.
Item number 4, madam.
Item number 4.
Madam, the matter has become
You have not
infructuous.
taken any steps.
No, madam, the matter has become infructuous, madam.
Infectious. Dismiss as infectious.
Madam.
At the request of the concept of the plant is significant, matter has become infectious. Dismiss as yes.
From item number 6 to 18.
Lordship, this is for, I'm requesting for item 9 and 10.
Item number
Lordship.
9, 10.
9 and 10. Your Lordship, I was in transit yesterday to Itanagar, where I am speaking from right now. I am appearing in court number 1 for some other item. So it's impossible for me to appear today. Lordship may post it for any fixed date next week, Your Lordship. At your convenience.
It will go after the summer vacation.
Lordship, there is some urgency in the matter. And last time your Lordship had asked me to file an affidavit counter rejoinder. I have already done that, your Lordship. I have complied. And any date next week, your Lordship, at your convenience.
Lordship, in this matter, we have to file a reply, Lordship. So let it be listed after vacation, Lordship.
Here, there is a request on the part of the other side that they have to file an affidavit in counter and therefore they are praying for the matter to be listed after vacation.
Lordship, they have filed an interim application for which your Lordship had asked me to file a counter. And it was your Lordship, it fell from your Lordship that on that basis, then I could place my.
What's the matter? By the way, what's the matter?
Your Lordship, this is a contempt matter. There is some urgency in the.
Urgency on the part of the state. You have to construct the road. What is the urgency? The urgency, you show this urgency in construction of the road.
Lordship, with due respect, your Lordship, I'm just trying to remind your Lordship that an IA was filed by them in a earlier matter, which has been closed down, which is already functus officio. And it is on that limited point I would like to argue the matter which.
Road and something. You have changed the alignation of the road and something.
Your Lordship, that was done in the PIL 101, which is in 2014 order.
27th of June. We are fixing it on 27th of June.
Much obliged, your Lordship.
Wait, please.
At the request, yes.
Item number 8.
8.
Yes.
Yes.
I've just been engaged.
You are on behalf of
Petition.
this Bharat Sanchar Nigam Limited,
Yes, yes.
BSNL.
BSN.
Section. Sir, last occasion we directed them.
Yes, Miller, that I have seen. They say that they will not be in a position to comply with it. I'm sure that. Because
Similarly situated persons.
no, it is a pan-India.
Already been granted, sir. Similarly situated persons have already been granted that relief. And very minimal relief.
No,
The court
Miller.
has simply said, engage them as a BSNL,
No,
not as a
Miller.
contractor.
Lot of things have not been placed before your lordship. It is a all over India repercussion. If it is done, Miller, it comes to about crores of rupees. Because other places also cases are pending.
Sir,
Give your lordship kindly give me 4 weeks time.
Sometime, my lord.
Mr. Sonko submitted that he has been engaged on behalf of the petitioners recently, and therefore he takes some time to prepare the matter. Stop. List on when?
4 weeks, Miller.
Summer vacation. List after summer vacation. Yes,
Miller, we will file an additional affidavit.
we'll see.
May I please, your lordship? Lordship, I'd like to mention with the consent of the appellant, item number 6. I need 3 weeks time to file my response affidavit in opposition in the IA, your lordship.
3 weeks.
Obliged.
Yes,
I beg to mention item 13, madam.
1-3.
1-3, madam. So the appeal by the state, madam. Today, madam, my senior, madam, campus is flooded, madam. You cannot come out. The flood due to that flash flood, my lord, this campus is flooded, my lord. Some other day, my lord.
Pass over for the day.
Oh, okay. Oh,
Pass over.
my lord. Oh, my lord.
May I please, your lordship, I beg to mention item 28 of the daily list, my lord, on behalf of Mr. K. N. Sodri, senior counsel, my lord. He is out of station, my lord, therefore I pray for an adjournment for the day, my lord. I have the consent of the
Go
other
after
side.
summer vacation.
28,
You'll go after
Obliged.
summer vacation.
my lord.
After summer vacation.
Obliged.
Your, consent of the other side is there.
I have taken consent of all the consent.
May I please, your lordship, I'm appearing on behalf of S. Borguhai. Item number 22. As per the last order, with the petitioner has to file a affidavit to the reply which was filed by respondent number 3. As the draft is not ready due to some personal inconveniences, my humble prayer is to fix the matter after 2 weeks.
After summer vacation. Yes.
Please, your lordships. I beg to mention item number 32 of the daily list, my lord. We have taken the consent of the petitioner in this matter. Senior counsel K. N. Sodri is engaged in this matter, my lord.
Adjourn.
It's out of station. Obliged.
May I please, your lordship, with the consent of the other side, I beg to mention item number 33, your lordship.
Yeah.
The advocate had some personal difficulty today and he has left, so some other day on.
Adjourn.
May I beg to please, your lordship? Lordship, I beg to mention item number 37, lordship.
Yeah.
Lordship, this matter may not be take up this bench, lordship. The impugn order, lordship, authored by my lord justice.
Another bench.
May please. The item 35 and 36, my lord.
Yeah.
In these matters, I'm led by learned senior counsel, Mr. K. N. Chaudhary, my lord. He's out of station today. I pray for some accommodation.
Summer vacation.
Yeah, deeply already.
Have you taken consent from the other side?
The airport authority, my lord, yes.
May I please, your lordship, with the consent of other side, I would like to mention, back to mention item number 30, items is 38 to 44. We are led by senior advocate K. N. Sodri, yes, sir. He is not available today, so item may be adjourned for a week.
Adjourn. After summer vacation.
Bless.
My please, your lordship. I beg to mention for listing for admission matter, my lord.
Application,
Admission,
admission matter.
my lord.
Is the old matter, pending matter?
No, my lord, 23 matter, but the notice issued on my lord, 29/11/2023.
Third week of June.
Highly obliged, your lordship.
Lordship, I'm praying for listing of an IA filed by the state for withdrawal, Lordship.
For withdrawal.
Yes, ma'am.
Get it listed today itself. What is the appeal or writ?
Lordship, it was appeal, the IA was for delay, which notice was issued on 6th of May.
Now you want to withdraw the IA
Yes.
as well as the appeal itself
Appeal also.
today itself.
Supplementary list for pronouncement of judgment, item 49.
That means you are not in- In view of the above discussion, we have no hesitation in holding that the appointment of the respondent number 7 as special public prosecutor in the designated special court in district of Barapeta to conduct the cases under the POCSO Act is not in accordance with law, and the same is not liable to be sustained. Hence, the notification dated so and so is set aside. The state government is directed to appoint a special public prosecutor in the designated special court in district of Barapeta to conduct the cases of POCSO Act 2012 as per law. The process of appointment of special public prosecutor in the designated special court in district of Barapeta to conduct the cases of POCSO Act 2000 be completed within a period of 2 months from today. Till such appointment of the special public prosecutor in the designated special court of district Barapeta, the petitioner is allowed to continue as the special public prosecutor in the designated special post of District Barapeta to conduct the cases of POCSO Act up to the period of 2 months from today. With the above observations, the and directions, writ petition is disposed of.
Also, it should be respondent number 7. Respondent number 7 to continue.
Allow the petitioner.
In place of the petition.
Allow the petitioner. Yeah, respondent number 7 will get it done.
Obliged.
Yes.
Daily list for orders item 1.
My lord, the case was last listed on 8/2/21, my lord, directed to say somehow, I apologize for that, my lord. I'll take fresh steps, or my lord, we have relied upon that page number 41, my lord, some cases of the Supreme Court that has already been disposed of. I'll place that judgment also, my lord. Page 41, similar matter, that was before the Supreme Court.
Page 41?
41, my lord.
Yeah.
That has also been disposed of. I'll place that judgment also, as per my information, my lord.
So what do you want?
I want, my lord, I will take steps and along with I'll place the judgment also, my lord.
Madam, the direction for taking steps was of the year 2021.
Yes, my lord. Yes, my lord. Yes.
What is this? Last 3 years, more than 3 years, you have not taken any steps?
That is, my lord, somehow I apologize, but I'll take the fresh steps, my lord, and that's why, my lord, after 2 weeks, my lord, I'll take immediate today itself, my lord, take steps. Today itself, my lord.
Please notice that this court on 8/2/2021 granted time to the state. To the union. To the petitioners. To the petitioners to take steps for service of notice upon the sole respondent. Full stop. The said steps have not been taken by the state till date. Full stop. Learned counsel appearing for the state praise has submitted that the steps would be taken within a period of would be taken today itself.
Yes,
Stop. In the interest of justice, last opportunity is granted to the state to take steps for service of notice upon the sole respondent, failing which this petition last opportunity of a day is granted to take steps for service of notice upon the respondent, failing which this writ petition shall be dismissed without reference to the bench.
Master bless, my lord.
Item 2.
May it please your lordship. Lordship, in this instant case, your lordship, I was directed to file the affidavit, your lordship. I have received the papers, your lordship, but where they have sent, your lordship, the format is not in proper format. That's why I have again recalled the papers, your lordship. And as per the previous date, your lordship, the petition I have already submitted, they are receiving the up-to-date pension, your lordship.
No, on
There was some
19
regarding
to-
the arrears,
Yes,
not arrears.
Lordship, in
Some
that-
other submission, what submission on the last occasion here?
No, my lord, on 19 to 24,
Yeah.
the council appearing for respondent 3 had submitted that we are getting less pension. Lordship will peruse the 19 to 24 order.
19 to 24 order.
Yes, Lordship. Mr. So-and-so appearing for respondent number 3 has submitted that petitioner is getting less pension amount and it is the fault of the concerned bank,
Yeah.
which is paying. So, so-and-so appearing for respondent bank has sought for and prayed that he be granted 10 days time to complete the. So,
In the last occasion, you said that you are not getting less pension, but dispute is regarding arrears.
yes, my lord, there are some arrears that has accumulated because in terms of that special seal authority from 1/1/2016, the petitioner's pension, basic pension had increased to 112,250. That was not paid for quite some time. There was some arrears that had accumulated.
Yes,
Regarding the area part, your lordship,
by what time you are going to file an affidavit?
lordship, after vacation, your lordship,
Not after vacation, sir.
after
To simply, why you are not paid the arrears and whether he is entitled for that or not.
the area part, your lordship, the clarification can come from the office of the accountant general, your lordship.
Miss Chaudhary, what is the amount according to you the petitioner is entitled to? Where is the pleadings or where is the material on that? What amount
I
are you
have
claiming?
filed additional affidavit in this.
Yes.
lordship,
Additional affidavit dated?
Dated. It's page 56 onwards, lordship. June 21,
Which is the relevant paragraph?
para 7, lordship. At page 64. 7 and 8. Para 8 at page 65, lordship, so kindly have a look.
No, we are asking you, where is the specific statement about what is the amount you are entitled to, amount of arrear?
My lord, the petitioner's contention is that from
Is there any statement that this is the amount of arrear you are entitled to and on this account?
No,
Any
my
statement is there?
No, my lord, but I have annexed the pension slip.
Which is that order you are complaining that it has not been, the directions given by this court has not been complied with?
There was a statement made by the learned counsel appearing for the respondent number 3, my lord.
Now, this is a contempt petition.
Yes, my lord.
And you have approached the court that they have willfully disobeyed the order. What are the ultimately directions given by this court?
It's para 18 onwards.
Direction is at pages 29 and 30.
So the additional quantum of pension is been received by the petition,
Now it has been paid.
but it is from which date it has been paid?
And now the petitioner's grievance is that the non-disbursal of
That's not the question.
Yes, my lord.
From which date is he receiving the additional quantum of pension?
From 31/7/2015, he was entitled to that 20% additional quantum.
Yes.
Which after the disposal of this honorable court's order dated 15/3/2015,
Yes.
he has been receiving it. But my lord, after from 1/1/2016, that was during the pendency of the writ petition, which was earlier filed by the petitioner, in terms of that special seal authority, the petitioner's pension amount had increased to, basic pension had increased.
If in between that, if rate of this pension has been enhanced, then you have to pay that enhanced pension also.
Your Lordship, at present, Your Lordship, as per the statement, the basic pension, the receipt.
You have to revise that, sir.
Lordship.
You have to revise that. And that's why only this pension period, pension from 1 month 2016 to November, it is concerned the same as when we paid to the petitioner. We have so far as the arrears pursuant to the revision of the pension from 1 month 2016 to November 2018, you have to pay the arrears also. On the 20th of November, we have clarified this.
This amount will be paid by the state. On being cleared by the bank is only the disbursement. No, bank is not the primary use. It's like all to where in the bank is Mr. Chaudhary, you are representing the CAG. CAG you are appearing for. And you are representing the Union of India. See, in these matters, the petitioner is a former judge of this court. So on retirement, his pension and other retirement dues will have to be borne by the state of Assam, right? Now, state will sanction the amount pursuant to approval by the CAG, correct? The state bank's role is only to deposit the amount in the account. They are neither to decide on what is his entitlement, how much he is going to get. These are none of the business of the bank. Now, can you tell us whether this adjustment pursuant to directions in para 32, whether the CAG has issued appropriate instruction taking into account the enhancement in the DA?
I will kindly take up the affidavit filed by the AG.
No, you just tell us first.
So there are two letters, my lord. One is to the pay and accounts officer. We have stated that a judgment was passed in 2018. Please enhance the pay accordingly.
No, that you made a telephone call or you
No,
passed on?
it's
Where
on
is that order?
It's on records.
Page.
This is the affidavit dated 21/1/22 by the AG, my lord. Respondent 3, page, mine is page 10, next year R3, bracket 2.
Page 10.
Page 161.
Lord have it.
So this 20% additional pension for the period from 37/2015 to 37/2016, that is the arrear you are claiming. Is that correct?
No, my lord, from 1/1/2016, there was a revision in the pension. So in terms of that, the petitioner's basic pension should have increased to 112,250. Now, the non-disbursal of that 20% of 112,250, which comes to 22,500 till November 2018. That's what is the violation of this honorable court's order. Because, my lord, the special seal authority had come into place during the pendency of this honorable court's writ petition.
That is correct, but the order of the court is for payment of that additional
quantum.
amount
Yes,
with effect from the date when the petitioner has turned 80 years.
yes, my,
Nothing more.
yes, my lord.
So has that amount been paid?
That has been paid. There is no.
Then you see, then it's a new issue. You may be entitled to, but in the contempt we cannot keep passing further orders, because if they dispute it, then how can it be decided in the contempt case? You may have a case, you may have a general. Is it not so? Fresh pleadings has to come to the. Because the pleading that is in reference to your elder future.
How much amount on account of this revision of pay as per your calculation?
Comes to around 8,59,051.
8,59,000.
Yes.
What was the this pension at the time in 2015?
My lord, his pension slips has been annexed at page 35, Lord. This is the pension slip for November 2020.
Mr. Bhattacharya ji, on 20th of May 2024, we have observed that though the petitioner is getting full pension as per the revised PPO, but so far as the arrears pursuant to the revision of pension from 1/1/2016 to November 2018 is concerned, the same has not been paid to the petitioner. This was their submission.
Lordship,
You submit your explanation.
we'll do that, my lord. I have sent there, my lord. Their answer is that whatever we had to do, my lord, pursuant to the order of the court, we have done. However, I'll get back to them again, my lord. I'll tell them.
You please get back
We'll
to
do
the
that.
management.
Your lordship will tell him,
Yeah.
mention that, my lord.
Mr. Bhattacharya, preparing for respondent number 3 and 4, raised for 10 days time to clarify whether the petitioner is to clarify that the arrears pursuant to the revision of pension from 1/1/2016 to November 2018 has been determined and paid to the petitioner or not. Just after 10 days के बाद की date दे देना.
A copy of the order, my lord. Copy of the order.
The copy of this order, the copy of the order dated 20th of May 2024, and the order passed today is supplied to Mr. Bhattacharya ji by the registry.
Obliged.
Much obliged.
Yes.
Item number 3.
All of this matter has become infructuous.
Yes. Dismissed as infectious.
Deeply.
IA is also listed. Yes.
Item 5.
May I please, Lordship?
Find the amended cost title.
Lordship, there is, my lord. I'll come to that.
As per the office report, amended cost title has already been filed. Let notices be issued to the respondents as per the amended cost title returnable. Yes,
Notice, I guess, I am appearing on behalf of the private respondent.
all the,
Yes.
and these are only the private respondents are the.
Lordship.
Yes, my lord.
And the state of Assam. They have already seen.
And consent to as per the office report, amended cost title has already been filed. Full stop. The, Mr. So-and-so put in appearance on behalf of the respondents, private respondents.
1 to 5.
1 to 5.
I'm for 8, my lord.
Mr. So-and-so put in appearance on behalf of the respondent number 8. Then Mr. So-and-so put in appearance on behalf of the respondent number 9. Service is therefore complete. This matter for admission, this IA is for what?
There is a delay of
Delay
370.
Yeah, what do you want to say?
My lord, I have filed my objection. The order is of, my lord, of the year 2018. And after that, my lord, there was an order passed by the learned single judge to obey the office memorandum and the memorandum of understanding entered into between the parties. As per which, my lord, BTC is held responsible to provide the financial.
Have you filed any counter?
Yes, my lord.
You already filed.
8/9/2023, I have filed my written objection. As per us, my lord, the delay is of 1,627 days. But so far as, my lord, the delay petition is filed, they have shown 370 days delay.
The registry had collected 370 days, my lord. It's
How?
not, my lord, the registry had calculated it as 370 days delay because most probably that the COVID period has been deleted.
Relax.
But there is no explanation to that effect, my lord. Because, my lord, the judgment was of 9/11/2018. After that, my lord, when we file a contempt petition,
9/11/2018 if the judgment is there, March 2020, you have to explain that delay.
No, they have explained the delay, my lord. Thing is that 370 days has been calculated by the registry, my lord. In paragraph number 4, I have explained the delay, my lord. Because after that, the first MOU was signed on 12/7/2011. It has a period of 5 years, my lord. The 5 years, in the meantime, the review petition has been filed. The 5 years that had expired, my lord. In the meantime, phase MOU has been sent, my lord, to the government of Assam. What you will find in page number 28 of my IA, my lord. That review petition, that phase MOU has not been endorsed by the state of Assam. And in the meantime, the contempt petition has been filed. It is pending, my lord. That's why, my lord, that this appeal has been filed. In the meantime, there is a delay, my lord.
there is a direction that writ petition to comply with the memorandum of understanding, since there is no change in the memorandum of understanding entered into between the parties, NTPC, BTC and the state of Assam, as per which, my lord, a notification was issued for appointment of 27 numbers of
employees in the IIT Salakati, my lord. But they, instead of complying to the order passed by the government, my lord, they are delaying the matter. Then we approach this honorable court by a writ petition. The writ petition, my lord, learned single just directed to comply with the order. But when they were sitting over the matter, my lord, we filed a contempt petition.
There was a review petition. also.
Yes, review petition was also dismissed, my lord.
Review petition is not.
If I may take your lordship to the last part of the review petition, that is page 26, it is clearly written in paragraph 13.
The period of MOU.
They filed this writ appeal just to circumvent the order and to get an order in the contempt proceeding, saying that the writ appeal is pending. Paragraph 13 of the review petition order is very clear, page 27.
That is a different matter. We are now on the delay condonation. There was a review petition filed in 2019.
Yes, my lord.
Which was disposed of on 12/3/2020.
Yes.
And the COVID restrictions came in from 20th of March 2020. So therefore, the delay which needs to be explained is only between the date of the judgment. This is 18/12/2018 till the.
That also has not been explained.
That they have filed a review petition and that was pending.
No, we have filed they have filed a review petition that was pending, but after that, my lord, after the review petition was dismissed by the honorable court, there is.
12/3/2020.
Yes.
And 12/3/2022, around March 2022.
Yes.
The COVID period was there.
2020. 20th of March.
20th of March 2020 and up to March 2022.
Understood.
The delay is condoned by the Honorable Supreme Court in all the matters.
But assuming for the timing, there is a delay of 370 days, but some explanation is required in the petition to explain the delay occurred in filing.
Consider it all that. So far as regarding delay is concerned. more or
Well,
less-
there is no explanation, my lord. Your lordship is aware about the judgment. Well, being a government department, they should be vigilant and diligent in their duty, my lord. While performing their duty, this appeal is filed just to get a take a plea in the contempt proceeding that the writ appeal is pending.
Will be listed this writ appeal in the next week itself.
Lordship.
The matter comes upon for consideration of the IN number so and so with a prayer to condemn the delay from 370 days in filing the connected appeal. Full stop. Having heard the learned counsel of the parties, we are of the view that इससे पहले जो what order we have written, service is complete. But we deem it appropriate. We are of the view that the delay in filing the connected appeal is satisfactorily explained. Hence, the certainly in such hence the IN number so and so is allowed. Delay of 370 days in filing the connected appeal is condoned. The registry is directed to register the connected appeal and list it for admission before this court on 18th of June.
You have written response number 9. There is only response number up to 7, is it?
Yes, my lord. And I am appearing for response number 1, 2, 4, and 6.
5 and 7 have been deleted.
5 and 7 has been deleted.
Deleted, my lord. They are no longer working.
We amended first.
On state of Assam secretary for the.
You get the
Chief Secretary.
presence noted on behalf of all that. Check कर लेते हैं हम लोग check.
5 and 7 delete करके लगा.
Problem.
Check it out.
Item 7.
Respondent number 2 and 4 and 3. Yeah.
My lord, may please your lordship. My lord, I appear for respondent number 1.
What about the other respondents?
Other respondents, I have no idea.
They also appeared in the bit proceeding, they appeared in
They
the.
appeared, but till now I have no information, so I cannot appear without
Information of what nature information?
I have instructions to appear only for respondent number 1.
And not material instruction from other persons.
Material, immaterial, both, my lords.
Seems.
My lord, let some time pass. I just conveyed that this matter is posted. So in case they want to engage anyone on me, whoever.
Await, yeah. Await return of notice of the answered respondent for 1 more week.
I'm grateful.
Nowadays, we have good electronic payment system.
Item 11.
Substitution application.
My lord, substitution application on behalf of press law number 6, my lord.
Yeah.
Is legal here is to be being on record as 6A, B, and C.
Okay.
And-
The matter comes upon for consideration of the IA number so and so. They pray to substitute the respondent, substitute the legal heirs of the respondent number 6 who reportedly expired on,
No, date is not mentioned, but during the pendency of this appeal.
who reportedly expired during the pendency of the writ appeal. Full stop. The other party has no objection. Full stop. The IA is allowed. The legal representatives of respondent number 6 are substituted. Amended cost title already filed.
Lordship.
Amended cost title.
No, postal has not filed.
Allowed.
After
Amended
allowing-
cost title will be filed. Amended cost title will be filed within the period of 1 week. You are appearing, anybody is appearing on behalf of the LRs of respondent number 6?
No, my lord. My lord, so far respondent 5 is concerned, the appellant has yet not able to collect the address because his address is already in sale. So 1 week time may require, my lord.
Thereafter, let notice.
Let notices be issued to the legal representative. Thereafter, let notices be issued to the legal representatives of respondent number 6, returnable 4 weeks.
My lord.
Ready.
Item 12.
May I please, my lordship? Lordship, my senior is busy on another court. Kindly pass over the matter for the time being.
It's all the increment.
Pass over for the timing.
Diplomas.
Item 14.
Yeah. Yes, you are for the
I am for the lordship, state respondent lordship.
state respondent.
Lordship, I kindly first, last parliamentary election lordship, he himself declared the Raha community lordship.
Oh, that's right.
Lordship. Paragraph 4, Lordship. It's a rejection order by the returning officer. Otherwise, Lordship, that time
So who is appearing for?
petitioner's counsel is
Non present. Adjournment.
Non present for the appellant.
Non present for the.
all eligible.
Item 15.
So here I am aggrieved by a judgment and order passed by the learned single judge on 1/5/2024. Well, the facts of the case is that, my lord, I participated in a recruitment process for laboratory assistant in the Fakhruddin Ali Ahmed Medical College. And being eligible, my lord, I was called for the written test. I succeeded in the written test. Thereafter, I was called for documents verification, where I have submitted all my documents or credentials. But thereafter, when I saw the list, my lord, published by the department, only
Vacancies are available.
yes, my lord.
But
And
they are saying that on account of some
Tie of marks, my lord, between two categories.
between the two persons of the OBC category.
yes,
Regarding that matter is pending. So how
Matter
can
is-
you say that those vacancies are available?
two vacancies are available till today, my lord. They have not taken decision. So what is, my lord, the judgment passed by the learned single judge is concerned, my writ petition was dismissed only on the ground that, my lord, the validity of the list is only for 1 year. But it was never my case that, my lord, I was selected and I should be appointed. My case was that, my lord, my name did not find place in the selection list, my lord, prepared by the department. In the note it is written that
Your case that persons who are more less meritorious, then they have been included in the select.
no, it is not my case. My case is, my lord, I being eligible, I should have been, my name should have been appeared, my lord, in the selection list, but the ground they have given, it's, my lord, for OBC candidate, there is a tie. My lord, there should be some, my lord, some provision to break the tie, my lord. My lord, my claim is based on the doctrine of procedure, legitimate expectation. My lord, where, my lord, some action on the part of the department requires, my lord, before coming into a conclusion and decision, my lord, some procedure should be followed. My lord, I have annexed some of the advertisements of other departments where there is a specific provision, my lord, in case of tie in marks.
But
My lord,
that matter now, this matter is academic, since the list has already expired. What
my lord, my claim is not based on the list, my lord. List is expired, my lord, for 1 year validity is there.
So no direction can be issued to include your name in the select list or to provide you the appointment.
But, my lord, they cannot, my lord, hold the entire procedure for, my lord, infinity, my
That's
lord.
fine, they should have corrected it, but now what relief, ultimately, what relief we.
My lord,
can
my relief, my lord, if I may take your lordship to page 44,
42,
44,
44.
annexure 4, the notice they have issued by which, my lord, 12 candidates were declared successful.
Sir,
And the last part, my lord, one post of laboratory attendant of unreserved category is kept vacant due to the candidate remaining absent during document verification, and one post of OBC MOBC category is kept vacant due to tie in marks until further order and notice. My lord, they are yet to publish or yet to pass an order, but it's been, my lord, more.
now this has already expired, where is the question of publishing that or resolving that issue?
My lord, I am not on the list, my lord. List perhaps might have expired, my lord. I am not claiming any benefit, any right accruing from the list published by the department.
Then-
I am claiming, my lord, the two candidates whose name was supposed to be there, but one candidate did not appear, my lord. There I have no objection because it's a general category candidate. So far as the candidate in the category of OBC is concerned, my lord, there was a tie. My lord, some provision should have been there in the department, like the other department, other government officials, my lord. In the 2020, one notification has been published to break the tie.
That is not your even case. You are not the persons, you are not the person whose case was kept in abeyance
Yes, my lord.
on account of
High of
getting
marks.
2 marks. But how you are?
My lord, my name has been kept in abeyance, my lord.
No.
My lord, my name was appearing in the list, my lord, written test list, my lord. Then I appeared for the documents verification and the
This
two.
vacant due to tie in marks of the 2 candidates. So you are one of the
Yes.
candidate amongst those
Yes.
2.
No.
My lord, 3 candidates were appearing in the OBC category. Out of them, my lord, I being the older in age.
Mr. Biswas, what is wrong with the judgment? Which part you are agreed with?
My lord, I agree with the finding arrived in by the learned single judge, wherein it is
Which
observed,
part?
my lord,
Which
the
paragraph?
validity of the
Which paragraph?
my lord, paragraph 6.
Yes.
There is another aspect of the matter which would have a relevancy and a bearing in the present adjudication process. The recruitment process was of the year 2018, which had culminated in the select list 25 to 2019. A select list is valid for a period of 1 year, unless the rules prescribe otherwise. My lord, I am agreeing by this finding, my lord, because I am not on the select list.
No. You have approached the court in 2022.
22, my lord.
23.
Well, before that, my lord, I was approaching the authorities with various representation applications.
That can be, and what is your right? Ultimately, no direction can be issued for giving appointment to you.
My simple right is based on the doctrine of my lord legitimate expectation.
Legitimate expectation.
Some procedure.
Mr. Biswas, legitimate expectation cannot be enforced in the court of law.
My lord,
Look up some judgments.
yes, my lord.
That will
I
help
have
you
brought
also.
some judgment. My lord. The recent one is 2024, where there was a question regarding my lord, judicial appointment in the my lord Madhya Pradesh. The court though came to a finding that my lord, the legitimate expectation of the candidates there, because in the
What is the principle? Legitimate expectation cannot be enforced.
well, and cannot be enforced, my lord.
Protection against arbitrary exercise of power.
Well, this is a procedure legitimate expectation where the claimant expects some procedure to be followed before coming into a conclusion, my lord. If I may read some paragraphs of 2024 judgment.
Sorry, that's correct.
Well, there should be some procedure, minimum procedure to be adopted by the department before coming to a conclusion that my lord, tie cannot be break. Well, had that tie been broken, my lord, my name would have been appearing in the selection list. I would have been appointed, my lord. This is my legitimate expectation, my lord. My lord, as a citizen of India, some expectation from the department is required, my lord. Some action from the department is required to solve the problem. But it's not that, my lord, they cannot keep it, my lord, pending for infinity. Some procedure to be followed before coming into a conclusion. No procedure has been followed.
You should have approached the court earlier then.
Well,
waiting till 2023.
Well, we're approaching the various authorities, my lord, by for representations to kindly look into the matter, my lord, because my lord, every time coming to court may not make sense, my lord.
Is that sit down? This writ appeal is filed by the appellant being agreed with the order dated 1/5/2024 last London single judge in WPC number 89/2020, whereby the London single judge has dismissed the writ petition filed by the appellant. Stop. There are two writ petitions.
Two writ petitions, my lord. One appeal has come.
Appeal in writ petition number?
My lord, this is writ petition of 548
2023, my lord.
by Himanshu Das.
54, this writ petition number 5485 2023, along with other connected writ petition. Stop. Both the writ petitioners have approached the court with a prayer to issue a direction to appoint them against the post of laboratory attendant in Fakhruddin Ali Ahmed Medical College and Hospital, Barpeta, advertised wide advertisement number 10/3/2018. Would stop. Dated 10/3/2018. The learned single judge has refused to interfere in the matter while observing that the recruitment process was of the year 2018, which had culminated in select list dated 25/2019. It is observed that the select list prepared pursuant to the recruitment process is valid for a period of, was valid for a period of one less unless the rules prescribe otherwise. It is further observed that in the instant case, the no relief can be granted to the petitioner as the select list has spent its force. And the force and the writ petitions are filed after the expiry of the said select list. Having gone through the material available on record, we don't find any illegality in the view taken by the learned single judge, hence no case for interference.
Before the page 61 may be looked into, my lord, there is a, my lord, letter by the authority themselves to solve the problem, my lord. If I may read page 61.
Council, once the list is already expired, whether
But it's
any
not about the
appointment
list,
can
my lord. I am not claiming any benefit out of the list, my lord. My lord, my lord, I may be clear, my
the
lord.
appropriate case, certainly in a
My lord, I am not claiming any benefit out of the list, my lord. My claim is that my name should have been appearing in the select list. Because of the tie, it is not appearing.
Even though, sir, if that your name was not appeared in the select list, the cause of action arose to you when the select list was issued.
But my right has been
Now
violated.
you are come before this court after the expiry of the said select list in which your name was not there.
But-
How can be granted
but-
relief, sir?
If I may clear, my lord, I am not claiming any benefit of the list, my lord. But page 61 may be looked into, my lord.
That way also cannot.
Learning concept of the appellant has submitted that as a matter of fact, his name is entitled to be, his client's name is entitled to be included in the select list, but the respondents have illegally not included the same. Stop. We are of the view that the said argument is also of no help to the appellant as the selection list prepared, as the selection list prepared pursuant to the recruitment process conducted in the year 2018 has already been expired on 25/2/2019. Hence, no relief for including the name of the appellant in the select list can be granted at this stage.
25 to 2020 expired.
2020.
Item 16.
Yes. Mr. Chakravarti,
Sitting there, he doesn't want to.
your name, last time election we hear. Yes, it is your case, Mr. Chakravarti.
Name has not been shown, Lord, in the
Yes, the case is yours.
My case.
Okay.
It's a cancellation
Yes,
of,
court.
cancellation of lordship selection process. We have cancelled the selection process. Lordship, we should have, day after tomorrow or Monday.
And the tribunal has ordered that complete the selection process.
Lordship. To declare the result and. Because some anomalies, we have detected some
This
anomalies.
Friday, after showing, after reflecting the name of Mr. Lee Chakravarti, then it's called CSD as counsel for the petitioner. Ask the registry, we have already passed this order on 15/5/2024, and why his name has not been included after this?
Item 17.
May I please your lordship? Lordship, this is again
or a petition filed against the order of the Learned Armed Forces Tribunal. And the operative part of the order, Lordship, I take your Lordship to paragraph 26. Page 26, Lordship. Page 26, Lordship. Now, as in the Lordship earlier case, reliance has been placed on Dharamveer Singh. And in paragraph 8, considering the law laid down by the Supreme Court and also the attending circumstances, the rejection of the claim of the applicant is set aside and the applicant is thus held entitled to disability pension from the next date of his discharge, that is 1/5/2008, at the rate of 50% as against 20% for life after being rounded off as per the judgment, so and so. Now, Lordship, if I may take your Lordship to paragraph 33 of Dharamveer Singh, which is quoted just above in this page. Yeah. Dharamveer Singh was a case where 30 or 33? I'm taking a Lordship to paragraph 33, the in Yes. italics. In Yes. italics. Lordship. As per rule 4. Yes. The general rules for the purpose of determining the question whether the cause of a disability or that resulting from disease is or is not attributable to service. It is immaterial whether the cause giving rise to the disability or that occurred in the area declared to be the field service, active service area, or under normal conditions. Classification of diseases have been prescribed at chapter 4 of Annexure 1. Under chapter 4, paragraph 4, post-traumatic epilepsy and other mental changes resulting from head injuries have been shown as one of the diseases affected by training, marching, prolonged standing, etc. Therefore, presumption would be that the disability of the appellant bore a casual connection with the service conditions, In that case, in Dharamveer Singh, Lordship, the petitioner was suffering from traumatic epilepsy. In the present case, Lordship, if I may take your Lordship to page 31. Page 31. Yes. What is he suffering from? DM, that is diabetes type 2, and dyslipidemia, that is, Lordship, I've just checked up, it's accumulation of fat in the blood, and that is related to obesity and unhealthy diet and lack of exercise. Now, this
order is 2 years old, more than 2 years old.
No, Lordship, what has happened here is, if I may take your Lordship to page 8. Page 8, I have, Lordship, given out the details why there has been a delay in what was the delay? in paragraph 8, page 8. After the order, Lordship, a miscellaneous application number 22 of 22 in OA 19 of 21 was filed by the petitioner for correction, modification of name, date of discharge of the respondent in order dated 31/5/22. The miscellaneous application so-and-so was allowed on 3/4/23. You are unnecessarily harassing these army personnel. No, Lordship. Not that. No, you should admit. Notice returnable from.
Item 18.
Let me resolve. The 3 points I like to urge. Limitation is one of the points, I'll take it. The query that has been put by your lordship, it is not only merit of the case it was decided, as I've understood. not on the merit of the case. Your lordship has said,
The learned single judge is not.
not on the merit of the case. Now I'll take your lordship. After going, your lordship will take a call on it, my lord. My lord, it is on the merit of the case. As far my submission, it will be decided. Why? I'll tell your lordship. 3 points. First point, which was before the revenue court, that is Deputy Commissioner Court, as well as Assam Board of Revenue, and how the Honorable Single Judge had replied. First, my lord, I'll just 2-3 minutes, my lord. 79, my mother expired. 80, my father expired. So the records of right was corrected in the year 1981. So accordingly, in records of right, the name appeared. Now, in 2010, application was filed by the claiming himself that his father was a riotee under us. So 2010, your lordship will kindly note down 2010, an application was filed by him before Deputy Commissioner Office. There's a revenue code.
Where he raised this plea?
This
2005?
2010.
Not 2005.
No, 2010. 2010, an application was filed. That your lordship will find a page 121. I'll take to that page, my lord. 121. Your lordship got it? 2010. 2010.
Yes.
Kindly see, this is 28/10/2010. That's your lordship will find in vernacular in 122. That's why I put the date 28/10/2010. That your lordship will find in vernacular, that's on the left hand side. Kindly see on the vernacular left hand side, extreme left hand side after 26, 28/10/2010. Lordship got it? 28/10/2010. On the left hand side, vernacular. If you see on the top, 28/10, that is page 122. 122. See on the
This, yes.
that's the date. Now, my lord will kindly see his application was filed. With due respect, we beg to inform you the land discount civil bill is under our possession since the time of father, and we are enjoying the benefit of the land. Righty Khatian has been issued in respect to the aforesaid land in the name of father on the basis of the possession, and land revenue is being paid. Therefore, in respect of land described in the serial name of the pattadar may be cancelled and patta be issued in the name of Righty on the basis of possession. Because my records of right, our name appeared because my father or mother died in 79. It is a part of record. Where your lordship will find it. Kindly see, my lord. Just your lordship will kindly see. My lord will kindly just give me for a moment. If your lordship kindly see page 91.
Such a Mr. Das.
Yes.
Continuing from where we stopped on the last date.
Yes.
The bench has taken note of the fact that the learned single judge has not made any adjudication on the merits of the case. It was only taking note of the procedural shortcomings projected by the petitioner, that the matter was remanded with the liberty to initiate afresh. Now, that's right. So, if the law permits to do so, they have been granted the liberty. So, in that context, we asked you, is there anything to show that as on date, law does not permit them to initiate the proceeding? If the answer is in the affirmative, we'll conclude the matter here. If it is not in the affirmative, then you are open to take all this pleas.
But your lordship is giving a handle, lacuna, this to cure the defect. After 30 years, I'm
Sir,
sorry to
even
say.
though after 30
Well, I'm
years-
giving a reply. My lord,
Mr.
your lordship can negate my reply.
Mr. Das, Mr.
Yes.
After 30 years or 50 years,
Yes.
if in accordance with law, he can't raise such plea, certainly you have a right to raise this objection
No,
before the court concerned where he is going to
My
raise
lord,
the
I'm just
plea.
giving a reply. I'm just giving a reply.
Yeah.
My lord, the learned single judge, your lordship expressed that on merit learned single judge is not decided. That's what I've understood. Now I'll just give a reply, my lord, in 1 minute. My lord, if your lordship looks into the judgment of the Assam Board of Revenue, what he decide? 3 points. First point, he moves in against a dead person. And this is a very important. With great respect, I'm submitting before your lordship. This is with respect. I'm saying it is not a procedural. It's on merit. An application has been allowed against a dead person. So whether number one, whether against a dead person such type of application can be allowed. This is one, my lord. Which before the Revenue Court Deputy Commissioner, we raised that point. Before the Assam Board of Revenue, that the issue was that whether against a dead person, he said no. Notice we received. Now, my lord will know that against a dead person also you cannot file it. There cannot be any substitution of legal heirs. This specific plea we have taken, that was nullified. So no, it can be proceeded.
By the Board of Revenue?
Yes, it went before now it was challenged before that's one point. That went before the learned single judge. We have taken that point. We have sort of a 4-5 judgment. We said how a application or a decree can be passed against the dead person. On that point, it should be rejected. Now there are 4-5 judgments of the Supreme Court.
Sir, we are affirming the judgment of the learned single judge. We are not differing. We are not differing from this judgment, or we are not taking any different view. We are affirming this judgment of the learned single judge. However, liberty is only granted if law permits to do so. He can raise such plea before the competent authority for he's claiming cathedral rights in accordance with law, or whatever cathedral rights or what
My
you
lord,
say.
it will be like with great respect, my lord.
Yeah.
I don't know, your lordship can take a call, my lord. I can make a submission as a lawyer, my lord. But to my understanding is number one, that once it is decided, this application. Second, even if but we have given answer. Maybe or we have to lay down.
Yes.
Yes. So number 2 point, this is one. The whether against a dead person, whether that application could have been allowed. Our argument that was placed before the Assam Board of Revenue as a revenue court was the same.
So are you saying that because the application was filed against dead person,
And no,
it would,
not application, sorry, not application. The application was filed under section 23. Simple, that he said, so and so, I am tenant, continuous in position. So under section 23 of the Assam Temporary Settlement Tenancy Act, 1971, he should be declared as an occupancy right? That's what. But when the notice was issued, it was against the dead person. Notice. And when the judgment was passed, it was against the dead person. We said before Revenue Court, you can't do it because it is against a dead person. And neither, today also, you cannot rectify it by substituting it. That's what you said before the Revenue Court. And before the Board of Revenue also, we took the same point. That's point number 1. Point number 2, we said that you cannot, because this degree, any application, decree, order, that's a nullity in law. Number 2 point, which we raised before the Assam Board of Revenue, that's a point of determination. Photocopy of the Khatian, whether it is admissible or not. Just pointing out towards the court saying this is a photocopy. We said photocopy cannot be admissible. The learned Board of Revenue said, no, there was a title suit, some title suit was filed by a third party against them, where right title interest was also claimed by a third party, where that suit was dismissed. It went to appeal, appeal was upheld. Some certified copy of Khatian was handed over. So now the learned respondent in the Board of Revenue, he now throws a paper before the court saying this is a photocopy. We said how a photocopy can be admissible under the Evidence Act. That was exactly a point which also was consideration before the learned single judge. Where the learned single judge, no, photocopy cannot be admissible. We have shown one judgment of the Supreme Court. This is number 2. Number 3 is regarding about the application, whether it was filed in a proper format or not. Learned single judge forget for a moment of the format. What about the verification part? Whether that any verification has been done when filing the application, it was not done. On these 3 counts, which was a part of the Assam Board of Revenue, that was decided by the learned single judge. To my humble submission, before your lordship, that number 1, if number 1 point is taken into consideration by the court, that no decree can be on application can be allowed.
Mr. Das, just a short interruption.
Yes.
Your argument that notice issued against dead person, order passed against a dead person, therefore it's a nullity.
Yes.
Is primarily based on several decisions which says that a decree against a dead person is a nullity.
Right.
Correct?
Right.
But we may point out that those judgments are all rendered in the context of provisions in the CPC as well as the limitation acts, which admits of a concept of abatement of a proceeding in case of failure to substitute within a period of time prescribed by the limitation. First is 60 days,
yes,
and the extended period is 90 days. Once no substitution is made within that period, the proceeding abates. There is a provision under the CPC for setting aside abatement, and that provision operates on certain settled legal principle. That is not the case in the present case.
I will,
because it is not a decree of the Supreme Court.
I will, lordship, I'll just differ for a moment, my lord, if your lordship permits, my lord. Your lordship is right so far as the substitution, abatement, but the judgment in those cases which we referred is purely on the point of any decree passed, not respect. I'll show those judgments. 4 or 5 judgments was placed before the learned single judge. Learned single judge accepted, subject to your lordship can look into those judgments. Whether your lordship just said for a moment on this point, your lordship can look into it.
He's okay if we don't give him.
My lord, my lord, these are 3 points which I can show it. Now, the 4th point, which your lordship raised, that's I have to give an answer to it. Because that's a point which was raised to me.
Yeah.
But whether any limitation, that's what I said, I have to go back and look into it.
Yeah.
Whether Temporary Settled Area Tenancy Act 1971 prescribes any limitation or not. To reply, the statute, this is a special law, there is no provision for limitation. If there is no provision for limitation, to whether Limitation Act 1963, where it provides, suppose that the mortgage is in respect of the immovable property, then 3 years, 12 years, all those limitations are provided. If it is not, and it's a special law, my lord, I have not found, frankly, any judgment on the Temporary Settled Area Tenancy Act 1971, point of limitation. So for the first time, I am raising it.
Mr. That's, please
Yes.
try to understand.
Yes.
We are not observing that he has a right to claim in this whatever the khatedari rights, and therefore we are granting him liberty. We are simply saying if there is any right available to the appellants to claim khatedari rights in accordance with law, then only they are having liberty to do so. Suppose tomorrow if they apply for sale and you have valid objections, no, you can't challenge that, you can't press this claim, then certainly you are free to raise all these objections before the trial court. We are not limiting your rights. Neither we are simply saying if he has any right, he can very well.
My lord, your lordship will pass this order, but my objection will be recorded.
Yeah, yes, certainly.
Your lordship, whatever your,
Yes.
but my limitation point,
Yes, certainly.
my limitation point under 137, my limitation, my lord, there was nothing wrong with respect passed by the learned single judge. That's what my submission is.
Yeah, we are completely in agreement with.
Now, my lord, the limitation point was very important.
Yes.
I said, my lord, your lordship knows, Urban Area Rent Control Act, these are all special acts.
All the possible objections.
Yes.
If in case he applies for that, all the possible legal objections you can take, you are also free to take.
My lord, 1971, that's very important. I have not found, maybe your lordship, I don't know, at some point of time, lordship can examine it. 1971, there is no statute doesn't provide for limitation. Took the help under 137 of the Limitation Act. So now 137 is for a period of 3 years. Now I have found judgment of the apex court, 3 judges. On the first point that whether it is applicable CPC, there whether any application 137, if it is a special law. So it's a special law on this Temporary Settled Area Tenancy Act 1971. How it has been dealt, first 2 judges, thereof the 3 judges of the Supreme Court. So how it was dealt, limitation point, my lord. I thought that I should give a reply to this.
Sure.
That your lordship can pass order, appropriate order. Because limitation, there is no prescribed, it is not prescribed under statute. That's sure. Urban Area Rent Control Act, there is no limitation, my lord. There is no limitation on those acts. It was 1935, your lordship knows, repealed and 1971 Act came into force. First, see Limitation Act, my lord. Limitation Act. My lord, kindly look into the Limitation Act. My lord. Yes.
Yes,
Yeah. Well, kindly see the Limitation Act for a moment.
yes.
Limitation Act. See, there are limitation of 1963, my lord. If you see first division, suits in respect relating to accounts, lordship got it. I think the same schedule, period of limitation.
Schedule?
Yes, first division suits, that's relating to accounts part one, lordship got it.
Yeah.
If your lordship turns to, this is account, now part two is there,
Contract.
yes, contract. Part three is relating to declaration. Part four, decrease and instrument. And
Declaration.
yes, and part five is suits relating immovable property. Now six is to immovable property. This goes on tort. Now lordship, I will not trouble your lordship. It goes on. Now it is now part two. If your lordship kindly see other application, last 137. 137. See, my lord, down. Any other application for no period of limitation is provided elsewhere in the division. So I didn't found any, my lord, limitation so far as the other divisions are concerned. So far as the special law is concerned. So it is, see, my lord, part two. Other application. Any other application for which no period of limitation provided elsewhere in the division, 3 years. Lordship got it, my lord? Lordship will go further down. I think last other application, part two.
Yeah, that application 137.
Yes, 137.
Sir, what, sir, try to understand, please.
No,
We are not saying that he has a right to do so. In case if he files any application for that, he can very well raise this objection. Why to deal?
No, no,
why
your
should we
lordship.
deal with the,
No,
at this
I am,
stage, sir?
my lord, I am fine with that. But kindly record this, my lord.
Yes.
My submission should be recorded.
Yes,
Because
Mr.
there are judgments on this point where your lordship has asked. I don't know, that's maybe your lordship may accept or may not accept this judgment. But what I found in the judgment, initially 2 judges said that it may not be applicable to the civil courts. Subsequent 3 judges said no. Revenue code definition I have seen that is applicable, any application. Any application also applicable, my lord. That's what it says. So kindly para 22, your lordship will note down 22, 23. And 19, my lord. 19, 22 and 23.
Yeah. Yes.
That's all, my lord.
Mr. You are agreeing to this now that this judgment, frankly speaking, this judgment is can't be interfered. That will note your admission, sir.
Yes, my lord, here is that that section itself, 23 itself says any application of ownership right may be filed at any point of time. I don't know where the limitation
We are
comes.
not on that, sir.
Yes,
We are
ma'am.
simply saying, so
Yes.
far as regarding this single judge judgment is concerned,
Yes,
you are frankly considering that there is no illegality in.
yes, ma'am.
Sure.
I'm deeply obliged, man.
Thank you. Close for orders.
Item 19.
May I please announce it? For the same matter, actually. In page number 31, actually. The under section
This for appearing for the state.
14, this the
Just a minute. Despite order passed by the collector, why you people are not taking any steps?
My lord, district magistrate is a executing functionary only. Hey, my lord, he can assist the creditors. But he is not empowered to, my lord, execute an application filed by the creditor.
Adjudication, where is the question of adjudication?
My lord, because he filed an application to assist him to seize the property.
So that is there, provision is
Yes.
there. That
What is-
provision is there.
My lord,
So that provision is there.
my lord.
That you are supposed to assist the this
Creditors,
bank or the
secure
financial
creditors.
institution to
Yes.
get the vacation of the get the position of the property.
My lord,
That is there.
my lord.
So what's wrong in that?
Anyway, lordship, I will take the instruction from the deputy commissioner why he is not.
Issue notice,
My lord.
Mr. So and so, accept notice on behalf of
20.
After 10 days, why do you?
Don't issue the notice. देखिए, you are appealing for the state. Ms. So and so for the state and Mr. So and so for respondent number 23. Raise some time to complete their instructions. This on
After 10 days.
10 days after they. Yeah.
Similar orders have been passed by this court.
I am.
Just agree on a date and
Yes, yes.
Provide necessary assistance to them, that's all.
Yes, ma'am.
what's the date? 19? 6.
19.
All right.
Item 20.
My lord, 3 weeks time may be granted to file affidavit in opposition.
To file?
Affidavit in opposition. I am appearing for respondent.
Mr. So and
Also,
so.
reclusion may be admitted and fixed for final hearing since my friend is appearing. And on last many occasion, he took time. And here lordship, great pay of 4,800 has been granted by the tribunal. But the rule doesn't provide for that. Lord.
Let him find a reply, if there is response. Then let him. Sir, so and so for respondent pays for the time to place 2 weeks for the time to file counter to the writ petition time period for is granted. Summer vacation के बाद
No.
Place 4 weeks time after summer vacation. Place 4 weeks time है ना? So time period for is granted list after summer vacation.
Item 21.
We have already filed our affidavit, my lord.
You have filed?
They
Right.
file your opposition, so we will file our counter. So some few more times may be granted.
Counter to the writ petition is filed on behalf of the respondents. The counsel appearing for the petitioner pays some time to file. Rejoinder, time period for is granted, list after summer vacation.
Deeply obliged.
Item 23.
Also, my lord.
My lord, in case I have been served with the response filed by respondent number 1, I take some time to file the reply, my lord.
And counsel appearing for the respondent, place some time to file counter to the reply filed on behalf of the respondent. Time paid for is granted.
Counsel for the appeal is there?
Item 24.
In this case, I am for the respondent number 6, my lord, received notice, my lord. We are filing Okalatnama today. The affidavit in reply was received, I. Service complete.
Yes, we are appealing for 7 and 8. 7 and 8. So what do you want? Appealing for time for filing affidavit of right. And you are also seeking
Yes,
time.
same.
Then counsel appealing for the respondent number 6, 7 and 8, place some time to file their response. Time paid for is granted. Place some time to file response on behalf of the respective respondents. Time paid for is granted. This stuff to summary.
Item 25.
Sorry, paper Union of India. Okay. We already filed a video position of the.
Rules for the petitioner. Present after summer vacation.
And present for the petitioner.
Not present for the
Obliged.
Item 26.
Petitioner's respondent.
For the respondents, I have received the instructions. Kindly give me 1 at a time for filing the affidavit.
Dean. Counsel appearing for the senior advocate appearing for the respondent place. How much time?
1 to 5, I prefer 1 week time. I'll give it after 10 days.
Appearing on behalf of the respondent number 1 to 5 place. 10 days.
10 days time.
10 days time to file counter to the. 10 days further time to file counter to the possibility. June last week.
Senior government advocate.
Item 27.
May I please, as your lordship, my lord, an affidavit has been filed, my lord, and their inter correspondence has been going on with the AG and the my lord Sarva Shiksha authorities, my lord, and some of the charges the AG has already been dropped, my lord. So, my lord.
Two or three charges remain only.
My lord.
2 or 3 charges will remain, but otherwise all the ordinary
Yes, yes.
sections have already.
Yes,
been.
yes, my lord. So, my lord can dispose of the petition also, my lord, or by the next date, perhaps, my lord, they are now going to drop the other charges also, my lord, as the
We are not.
my friends are
whether
there,
we
my
are
lord.
going to drop the
We are not-
charges or not.
Yes, it is the prerogative of the AG, Lord.
AG, my lord.
We are furnishing whatever query has been sought from their side, Lord.
we are furnishing information that has been sought from the AG lordship, but ultimately it will be the prerogative of AG only.
Initially, how many audit objections were there?
My lord, initially 43 charges was there, my lord. And then
Charges or objections?
objections, my lord, that there are some anomalies in the, my lord, fund transactions. my
So
lord.
in this audit report, there are some objections.
Yes, yes, my lord.
Which they have to satisfy.
Yes, yes, my lord.
And they have satisfied almost all the objections except 2 or 3 objections.
My lord, 21 they have dropped. As per the affidavit file, 21 objections they have dropped and remaining, my lord, 22 are still there, my lord.
Okay.
So regarding that 22, what is the status, my lord? My respected friend may, my lord, apprise my lordships, my lord.
Yes.
Okay, I will apprise, no issue, lordship, but that is the same instruction, lordship. Whatever query they are raising, lordship, we are replying, lord.
Has submitted pursuant to direction given, additional affidavit has already been filed. When you have filed additional affidavit?
Lordship, the additional was one file on February 2024.
February 2024. Is filed by Sanjoy Datta?
Yes, lordship, executive director. Yes, sir.
Development of first day of March 2024. Similar relations with dispute provision level.
Second one.
Three para has already been dropped
Well,
by objections. Now, what about the remaining objections?
Lordship, in my affidavit, lordship, one statement has been made in that regard, lordship.
For examination, early settlement of the same by the said authority and reply against one outstanding paragraph is being prepared for onward submission of the Principal Accountant General Audit Assam.
one letter from Asalasta. Mechanism. The idea that the review is already taken. Obviously, yeah, legal. Yeah, that's good.
What if in the second affidavit at page 286, Lordship, one annexer is there, it's a letter by the mission director, Lordship, to the principal accountant general.
Two, page
Page 286, Lordship.
86.
Second affidavit, Lordship, it is affidavit dated 2nd of March, Lordship.
Second of March,
Affidavit, Lordship. It's a letter
March 2024.
24, Lordship. Running page is 286.
This is by Sanjay Datta Hoy.
Yes, in the same affidavit, Lord.
The same affidavit, yes,
One annexer is there.
one annexure. Annexure is there. Where is that? Okay, submission for the reply. AG often bearer confirm. Okay. This AL petition is filed by the petitioner with the prayer to issue a mandamus of this effect, issue a mandamus to the respondents to cause a high-level inquiry to find out corrupt officials of the Assam Sarv Shiksha Abhiyan mission who are involved in corruption and misappropriation of government funds allotted during the financial years 2011 to 2019. To stop, the petitioner has relied upon the audit reports of the Accountant General Audit Assam to substantiate his claim that to substantiate his claim that the officials involved in the said Abhiyan are involved in corruption and misappropriation of government allotted funds. To stop, it is claimed by the petitioner that in respect of the said irregularities, he has already filed a complaint on 3/8/2019, 30th of August 2019 and 2/2/2021. However, the respondents are not taking any action against the erring officials. To stop, during the pendency, affidavits, counter affidavits have been filed on behalf of the respondents, wherein it is emphasized that the Auditor General, Principal Auditor General, Audit Assam is seized of the matter, and out of the 43 audit objections, after getting a reply, a satisfactory reply and explanation from the authorities concerned, 23 objections have already been dropped. It is further submitted that in respect of the other audit objections, reply and clarifications have already been sought. And after considering the same, those audit objections would be dealt with, dealt with And if any irregularity is found on behalf, irregularity is found on behalf of the irregularities found on part of the officials concerned, appropriate action, recommendation for appropriate action be sent to the state government, full stop, to the concerned department. The concerned department, stop. Taking into consideration the above facts and circumstances of the case, when the Principal Auditor General Audit, State of Assam is seized of the matter and is proceeding, seized of the matter. And the allegations are of financial. And the allegations are of financial irregularity. We deem it appropriate to dispose of this writ petition with a hope and trust that the Principal Auditor General Audit Assam shall deal with the audit objections, shall decide those audit objections expeditiously in accordance with law. And if any officers are found, and if there is any involvement of any government officials in misappropriation of the funds made available for Substitution Abhiyan, appropriate recommendation for taking action against the said officials will be sent to the state government. Stop. On receiving such recommendations, the state government, receiving such recommendation, it is expected that the state government shall proceed in the matter in accordance with law. These observations, this PI petition is disposed on.
Item 29 to 31.
May please, your lordship. Also, item number 29 to my lord 31, similar matter, my lord. They filed an objection and we finally reply in respect of item number 30. Lordship may be allowed to item number 30, my lord.
Yeah.
I file in reply in 30.
You want to file reply?
My lord. No,
To the objection to the state or by the respondent.
respondent filed an objection, similar matter all three, and item number 30 I have filed in reply, my lord. Already filed reply, my lord. Probably, my lord.
Item 13. In the counter, in the 30.
In this matter, my lord, regarding my lord, all are in casual labor, my lord, under BSNL, my lord. They are working since my lord 1988 to 99, my lord, from onwards, my lord. And my lord, in the year of 25/3/1996, my lord, 27/5/96 granted in temporary status, my lord. And petitioners' names are also there in the list of the, my lord. Please may kindly see grant of temporary status, my lord. Page, my lord, 36, my lord. Page 36, my lord. 27th of May 96, my lord. All the petitioners is there in page 38, my lord. They were given the temporary status.
Where is the judgment of this court? 30th of August 2017, which page?
Page, my lord, please may kindly see. Page 134, my lord. And operative portion, my lord, page 141, para 6, my lord. May I read, my lord? Para 6, my lord. Page 141, my lord. Having regard to the aforesaid order dated 19/11/1997, it is seen that same was ignored from the consideration while rendering the second cancellation order 24/5/2011. Also in the present order of the tribunal under challenge, no discussion whatever or any mention therein is found agreed with regard to the revocation order.
So your basic case is that your clients are also similarly placed as those.
My lord, we are in approach.
That you agree?
Yes, my lord.
No, my lord.
Then you have to produce the records substantiate.
My lord.
Why they are not similarly situated?
My lord, the fact is that firstly, their engagement records of that particular period, which would make them entitled under the 89 scheme, is not available. The other set of persons who got benefit, my lord, that was because of this court order, which say that that order has to be treated as cancer. If that be so, my lord, the matter went to the Supreme Court. Supreme Court just dismissed the petition. There was no finding as such return as to the aspect about engagement. The other set of persons, my lord, therefore, we had given them the financial benefits. But then these persons, my lord, they were never brought into the establishment of PSN. They remain, my lord, though engaged, they remain engaged thereafter after ban on engagement of casual laborers, were engaged to contractors only.
Those persons to whom you granted benefit, they were not engaged by the BSNL, or they were engaged by the BSNL and continued?
It was, my lord, an engagement in the time of Department of Telecommunication. Subsequently,
Respect of those persons, records were available.
they were available. So it would take some, my lord, the production of records and some time would be consumed, my lord, in hearing, my lord. It can be therefore taken up on some other date. I'll place that record also, my lord, of the other case, my lord.
Matter requires consideration, will admit those.
My lord. My lord.
Having heard the land council for the parties for quite some time, we are of the view the matter requires consideration, hence admit. Readings are already complete. Readings are already complete. This matter for the hearing in the due course. These matters for the hearing in due course.
Deeply aware.
At the time of hearing, the learned counsel for the department is directed to produce the relevant record.
Hearing them thing after vacation, man.
Jaldi aa jayega. You come early.
Marks.
Yes.
Passover meter 12.
Wait, please, your lordship. Lordship, this petition is directed against the order dated 24/4/23 passed by the tribunal by which the OA was allowed, lordship. Setting aside the order of punishment, the punishment was withholding of 1 increment, lordship, annually. Now, lordship, in this case, the watchman was, lordship, it's a fact that he was found with the 21 bottles of rum, lordship.
Where was the fact?
Lordship,
Those bottles were of
the criminal court held that
liquor or some sharbat or something else.
that is the finding of the criminal court that it was not proved because what was contained because FSL report was.
Court has said you have not proved that these are the bottles of liquor. Then how you can?
Lordship, that
you have imposed the penalty only on the basis the FIR has been filed against.
Lordship, the fact that he was found with the 10 bottles of liquor, that has risen.
That fact has also not been substantiated
No,
by
lordship,
any of the evidence.
Lordship, the criminal court said that only 1 witness was examined, even the Caesar witness was not examined. That was the finding of the criminal.
No, this is not.
Yes, lordship.
Finding of the criminal court, apart from that, sir. Ignore the finding of the criminal court.
Because the tribunal held that the facts and circumstances being same, that's why the charges being same.
No.
But the charges are different, lordship.
No.
Charges in the criminal case was under Bengal Excise Act, lordship.
Sir, that the said Nirmal Senapati watchman Kolkata by his above act so and so. What was the act? Statement and impugned so and so. Watchman was caught red-handed by the police, approx carrying 21 bottles of liquor, different brands, illegally.
Lordship.
This was the charge.
Lordship.
Now come to the evidence.
Lordship.
Para number 13.
Lordship is reading from page number?
Page number 77. The tribunal has discussed those witnesses. The evidence given by the witnesses has been as under.
Lordship.
PN 79, the other thing is stated during examination, he has signed and forwarded document based on the facts and figures available, and after obtaining FIR copy, he was on leave during the day of the no cross examination was done. Nursing Rao has stated the examination that he came to know about the incident next day. From security agent, he went to the intelligence unit, he came to know Shri Nirmal Singh Senapati has been taken to the court. During cross examination, he asked security in charge to follow up and inform the manager on telephone. Jugal Kishore, on his duty, he came to 9 PM. The 12, around 10, 12 people around Senapati with 4 people uniform and gypsy standing nearby, sitting on a chair during cross examination, get inside and he did not see any liquor bottles. Same is the
These are the DW's, Lordship.
non-Kulal, he stated that went to away filling water. When he came back, saw Gherowing Nirmal Senapati and blank papers. Nirmal Senapati inside the vehicle, he was asked by the other watchman about what has happened, but did not do anything. On cross examination, that nobody asked him anything, did not see. Was asked, he replied, this was the so and so. Ab ye the evidences.
Lordship.
What is the evidence?
Lordship,
To prove this charge that the person was carrying 21 liquor bottles. What is the charge?
Lordship, charge memo is at page 28, Lordship.
Yeah.
And the article charge page 29. May I read, Lordship?
Yes.
That the said PN so-and-so Sri Nirmal Senapati, watchman, CSD Depot, Kolkata, was caught red-handed by the police station Baidan, Calcutta, night for having illegal possession of 20 bottles of liquor, different brands, each containing 750 ml meant for the consumption of armed forces. Now, the charges for possession.
Brands, which are those brands? Well, actually, you have to prove, sir, that those bottles were having liquor.
Lordship, he was doing for a long time, Lordship, that's why.
Huh?
On tip off, he was caught, Lordship.
If the police has got him and the police has failed before the criminal court, they have failed to prove that these were the liquor bottles.
Because one witness was examined, Lordship, no, or seizure witnesses or none of the seizure witnesses
Apart from that,
examined,
sir,
Lordship.
what is the evidence before this disciplinary authority to come to the conclusion that he was guilty of misdemeanor?
Lordship, the inquiry report I have annexed, Lordship. May I read from page 35, Lordship. 35.
38, 35.
35, Lordship.
35.
35. JKL. L, Lordship. The evidence given by witnesses. Start from.
Yeah.
The evidence given by witnesses has been as under PW 79. That has been Lordship, the reputation. M, may I read from M, Lordship. The analysis and assessment of evidence adduced during inquiry and assessment of document is under. All listed documents have been admitted by SPS and DA. During inspection of document, no additional document was asked for by the SPS and DA. Listed document includes FIR number so-and-so and against which no dispute or observation has been made by SPS and DA. As per evidence of Sri Dayal Singh, this action was based on fact as per FIR copy received from police. DA did not do cross-examination or raise any doubt dispute about the authenticity of facts in FIR. In other words, facts in FIR stand to be admitted by SPS and DA. Evidence of A. Narasimha Rao established that the incident did took place and he followed up with the intelligence people next day till 12:30 hours, and when he came to know police had taken him to court. Evidence of 3 defense witnesses was recorded. None of these defense witnesses is eyewitness to case. None had talked to either Nirmal Senapati or the police people who had apprehended Nirmal Senapati. So Nirmal Senapati has himself admitted that there is no eyewitness to the case. All 3 defense witnesses have stated that they have not seen any liquor bottle. Lordship, it's established fact, Lordship. In a departmental proceedings based on preponderance of probabilities.
No. This writ appeal is filed by the filed by the petitioners being agreed with the order dated 24/4/2023 passed by the Central Administrative Tribunal, Guwahati Bench, hereinafter to be referred as CAT, whereby the OA filed by the 24/4/2023 and order date of, whereby the OA filed on behalf of the respondent has been allowed, and the punishment of withholding of one grade increment
One annual increment.
one annual increment for 1 year imposed upon the appellant, upon the respondents by the
For a period of 1 year with cumulative.
with cumulative effect, for a period of 1 year with cumulative effect imposed, they are awarded by the respondents to the awarded by the petitioners to the respondent as being set aside. Full stop. The defects of the case are that the appellant, that the respondent, while working as watchman CSD Depot Kolkata, was arrested by the Maiden Police Station Kolkata and was detained in police custody on 25/4/2005 on the allegation of illegal possession of 21 of liquor, 21 bottles of liquor meant for consumption of armed forces. Full stop. It is the forces. Full stop. For the said, in connection with the said FIR, charge sheet has been filed against the respondent, and he was put to trial after claiming of charges. However, the trial court has acquitted the concerned criminal court has acquitted the respondent from the aforesaid charges. In the meantime, disciplinary proceedings were initiated against the respondent by the petitioners, and he was and a punishment was imposed upon him. Why the impugned order?
Lordship, page 44, 8 February 2007.
8 February 2007, withholding one annual grade increment for 1 year with cumulative effect. Full stop. The appeal filed by the respondent before the appellate authority has also been dismissed, and being agreed with the same, the respondent has preferred an OA before the CAT, and the said OA came to be allowed while order dated 24/4/2023. Stop. Assailing the impugned order dated 24/2023, Mr. B. Chakravarti has argued that the learned tribunal has failed to consider that the acquittal from the criminal case cannot be treated, cannot be taken into consideration in all the cases for setting aside the punishment order awarded in the departmental proceedings. Full stop. It is contended that it is settled that the proof of the standard of proof in relation to standard of proof for in a criminal case and in the departmental proceedings are altogether distinct and different. And in every case where a person is acquitted from the criminal charges cannot be cannot be discharged, cannot be in every case, the punishment order. In any case, in every case where the incumbent is acquitted from the criminal charge, the punishment imposed in the disciplinary proceedings cannot be set aside on the said ground. Stop. We are of the view that there is no quarrel about the above proposition of law, but in the present case, the tribunal, the CAT has not set aside the penalty order on the ground that the appellant, that the respondent has been acquitted by the criminal, competent criminal court, for which in the FIR lodged against him. As a matter of fact, the tribunal has discussed the evidence produced before the disciplinary authority in detail, and thereafter has recorded a finding that on the basis of the said evidence, it cannot be said that the charge of carrying liquor, 22 liquor bottles, 22 or 21?
21 bottles.
21 liquor bottles illegally has been proved against the respondent in disciplinary proceedings. Full stop. Having gone through the impugned order as well as the material available on record, we are of the view that the learned tribunal has not committed any illegality in setting aside the penalty, setting aside the order whereby the penalty has been imposed against the appellant, hence no interference against the respondent, hence no interference called for. Let the petition dismissed.
Lordship, in appeal, he admits that the facts are different, charges are different in appeal paragraph, Lordship 11, Lord. In paragraph 11 of his appeal.
No, independent of that, they have also discussed the evidence. The tribunal has discussed the evidence in detail. Yes.
Production list for withdrawal item 1.
Lordship, a communication has been received directing us to withdraw the appeal.
For withdrawal of the.
Yes.
Yes. Learned counsel for the. Mr. B. Chaudhary. Mr. B. Chaudhary, learned counsel appearing for the state of Assam and others has submitted that as per the communication dated 27/5/2024.
Lordship, second.
Received from the Director of Agriculture, Assam, Guwahati. The department, the state is not pressing, the state is not pressing the IA number, the state is not interested in pursuing the IA number so and so, so and so. And therefore, he pays that the IA number as well as the container, IA number 1272/2024, 4467/2024, and filing numbers are there. You go through it. And writ appeal number 4466/2024. In view of the above, these IA as well as the writ appeal are dismissed as not pressed.
For hearing item 34.
So this is appeal by the revenue. But please to, there is the order dated 30th of March 2023.
Yeah.
Lordship, order dated 30th of March 23, Kalimi Peru.
28th of March,
30th of March,
30th of March 2023.
Lordship.
Which was the respondent?
Uh, Counsel was Mr. R. Goenka.
But his name has not been shown.
Lordship, what happened, when the dishonorable court directed them to produce original records on 21st March 2024, Learned Counsel make a prayer that he has not received any instructions, so he want to withdraw, and he was allowed to withdraw from the case.
Then notice has to go to the respondent.
Lordship,
Then notice will have to.
yes, notice was issued by the registry, but probably that has been returned unserved. Lordship, there is the order dated 21st March 24 also.
Okay. It appears that the counsel appearing for the respondent has pleaded no instruction in such circumstances that notices be issued, registry is directed to issue notice to the on 21/3/2024, this court, while taking note of the fact that the counsel for the respondent has pleaded, has withdrawn his vakalatnama, directed to delete the name of Mr. R. Goenka and his associates from the cause list. Full stop. It appears that at present none is representing the respondents, therefore we deem it appropriate to issue notice to the respondents returnable 4 weeks, requisites be filed within a period of 1 week.
We have to take a step. What's another thing, the council was allowed to withdraw without any application.
Withdrawal of the vakalatnama and the court has allowed.
No, Lordship, court is allowed, but there was no application, formal application.
Yeah, either you review this order or file a review for this order. Once
I'm just
this order
pointing
is
out.
passed,
That's a wrong way.
Lordship, another thing, registry issued the notice, but it was returned unserved.
In the correct postal address.
Yes, sir.
correct post.
Respondent, not respondents.
For hearing, item 45 to 48.
May it please your lordships. I am appearing lordships in item number 45 and 46. If I may broadly say. Well, I'm dealing with four. There are four of them. Four of them. Yes, Lordship. I'm appearing in item 44. There are 4 appeals in total.
Identically, almost all.
Yes,
the-
yes. No. Therefore, that is where I want to make a difference.
Yeah.
I am appearing only in 2 appeals which pertain to Dibrugarh and Goalpara. So my colleagues, friends would be appearing in the other appeal. So my argument would only be limited to these 2 because we believe that because all these matters were heard together, the distinguishing features in our case unfortunately got sucked into the whole thing. That is.
Either when the Randy Singhal is recorded a finding that all these appointments were illegal or suffering from certain irregularities.
Well,
That is not the
lordships.
common finding of the Learned Singhal.
So lordships, broadly, my submission would be on 3 limbs. The first limb of the submission would be, at best, there has been a compliance with the constitutional mandate. Largely, there could be a little bit deviation from the rules. So at best, these appointments can be termed as irregular and certainly not illegal. That is my first limb.
In respect of these 2 districts.
Yes. in respect of these two districts.
So that argument is not available in respect of two other districts?
No, that I don't know whether we have advertised this. That he will address, my colleague will address.
Other cases in those cases or in your case? Your mind, your cases.
So by first limb of
At two?
very much. Well, grateful. Lordship, in this, Lordship may take up this Narayan Rabha appeal. It is the second matter in.
Narayan Prasad.
Yes. That's
This one is perspective. This Narayan Joma. This one is Narayan.
Achha, this.
This is the appeal that arises from Goalpara. Now, in these two appeals, that is Goalpara and Dibrugarh, there are a total of 34 appellants. 17 each from Goalpara and Dibrugarh.
This rate appeal number?
This is rate appeal number 428, Lordship. 428 of 2000?
428.
Of 2023.
Yeah, is of
District Goalpara. And the cause title is Narayan Rabha and 16 others was the state of Assam.
And the another is?
Other one is rate appeal 429 of 2023.
Yeah.
This is pertaining to Dibrugarh. And here also there are 17 appellants. And the cause title is Lombit Kaur and 16 others.
With the, yes.
Yes, Lordships. Now, broadly, Lordship, there are, I am for 34 appellants. They were appointed as grade 4 employees in 2005 against vacant and substantive vacancies under the Joint Director Health Service and continued as such until their services were terminated in 2019.
2005. Exact
Yes.
date of the appointment?
Yes, exact date of the appointment is, Lordships. There are various dates. 2010-2005 is at page 167 of the paper book.
2010-2005 to?
Where is it? 29-2005. There are various dates, but this is all in 2005, Lordships.
All in 2005.
2005. And they were terminated in 2019.
Yeah, the post was?
These were all grade 4 employees.
Grade 4.
Another aspect that Lordship will appreciate is all through their service period, they receive the regular salary without any break. The termination of the services after rendering almost 14 years of service has been upheld by the learned single judge by the impugned judgment. Now, as I, in the pre-lunch session, had indicated, I will be broadly submitting I will be advancing 3 submissions for your Lordship's consideration.
Terminated by whom?
Terminated by the Joint Director Health Services of Goalpara. And if Lordship wishes to have a look at the termination order, that is at page 1013. Termination order is 28th of October 2019. Page 1013. And similar orders were passed in respect of all the appellants.
1013.
Yes, Lordships. Hello.
Silent, sir. Silent reply.
That is of
28th of October 2019.
19. This is in relation to 1 out of 17. No?
Yes, and similar orders were passed in respect
And
of
all
all.
yes, read this order.
Yes. I'll read this order. To Narayan Rabha, so-and-so, removal from service. Letter dated HSC verification grade 480, so-and-so dated 22/10/2019 of the Director Health Services, Assam. It has been informed by the Director Health Services, Assam, as per his letter number so-and-so dated 22/10/2019, that you have been detected to be fake by the Scrutiny Committee of the Director of Health Services, Assam. It has also been informed that you could not establish the genuinity of your appointment, and hence you are hereby removed from your service with immediate effect as directed by the Director of Health Services, Assam.
The person is fake or the appointment is fake?
They say the appointment is fake.
Appointment is detected to be fake.
You have been detected to be fake.
I have been detected to be fake, but the appointment is fake. Now,
The sum and substance, the appointment is.
appointment is fake. So now, Lordships, as I indicated, my submissions will be threefold. First is that the appointments certainly are not fake. It can at best be irregular, not illegal. We'll demonstrate it.
But this 22/10/2019, this verification report of, or whatever it may be, Director of Health Services, as per his letter.
Yes, that
Is
letter,
this
Your Lordship may like to have a look. It is at page 1010.
1010.
Just 3 pages before that. Annexure 26.
Yes.
Yes. The subject to the Joint Director Health Services, Gwalpara, District Gwalpara. Subject removal of from services of 81 north of grade 4 sweeper employees whose appointments proved fake. Refer government letter so and so. Sir, with reference to the government letter and subject cited above, I am to inform you that 81 numbers of grade 4 sweeper employees under the jurisdiction, the list enclosed, have been detected to be fake by the Scrutiny Committee of this Director of Health Services, Assam, and further they could not establish the genuinity of their appointment, and hence you are hereby removed. No, you are hereby directed to remove them from their service with immediate effect. There's a little problem in the English, I guess. You are hereby directed to issue the removal order individually and direct to submit the compliance report to DHS Assam at the earliest. You are further directed to lodge FIR against those fake employees in the local police station.
So what was the occasion for verifying all these appointments? Is there any complaint? There was any complaint or what?
I'll tell you, Lordships. The Lordship will then straight come to why did this start? In fact, before that, may I just, Lordships, briefly illustrate that there was an advertisement. We are from the open market. There was a proper select list drawn up. The select list was sent to the Director of Health Services. If Lordship will just seize those documents, and in that background, can these appointments be termed as fake?
Let me see just how these proceedings were initiated.
Yes. I will just tell, Lordship will come to page 327. Page 327. This is how it started. In fact, earlier the inquiry was with respect to some other employees. If you Lordship see dated 27th March 2017 letter. His Lordship's
327, yeah.
Volume 2. Volume 2.
Yes.
My Lord, this is come.
Yes.
This is 27 March 2017, Annexure 3. From Mukul Gugoi to the Director Health Services, Assam, Hangrabari, so and so. The subject was regarding release of salaries of surveillance workers. Please mark the word surveillance workers. We are not surveillance workers. Sir, with reference to letters on the subject cited above, I am directed to request you to release the salaries of 953 number of surveillance workers whose credentials were found to be genuine by letter dated so-and-so and consolidated statement of verification. Now, I'm also directed to request you to please give one opportunity to those surveillance workers who did not appear before the screening committee to appear before the same once more, failing which suitable steps will be initiated for the termination. Notice in this connection may be given in the form of newspaper advertisement, also at an early date. Thereafter, further, you are requested to complete the screening process in remaining surveillance workers and start similar process for other posts also under your establishment so that their genuineness can be verified. So we came under this last sentence. A report in this connection may be submitted earlier at an early date.
Now,
yes, Doctor.
Your main contention is that your appointment, though you can it can be termed as irregular but not illegal. And advertisement were there, appointment were there, you were getting regular salaries or all. So how these contentions have been dealt with by the learned single judge, you please refer to us.
This is
We first want to go through that that part of the judgment where these contentions have been dealt with by the learned single.
Yes. Please come, Lordship, to straight to page 1502, para 88 onwards.
Yes, 1502.
Volume 5. Volume 5.
X. 301.
The volumes are not marked as volume 1, 2, 3.
Sorry. So even operated one thing. All those 5 volumes are inside.
Sorry?
All those 5 volumes are here. Lordship will find it far convenient.
No, there's no marking of volume 1, volume 2, volume 3. No.
Start of volume 5. 1201. Volume 5 starts from page 1201.
That's right, but it's not written volume 5.
Oh, sorry, Lord.
1201.
That is from where volume 1 starts. Volume 5 starts.
Now the judgment starts from 1456.
Yes. 1456.
And you are referring to para 88.
Para 88.
88. Yes, 1502.
Therefore,
just a minute.
I'm sorry. Therefore, from the above analysis, it would be seen that all the appointments which were made favoring the petitioners in the instant batch of writ petitions were dehors the rules of 1997. The appointments so made prior to 36/2005 not only did not have SLEC permission, but were also made during the ban period, which was in existence from 11/4/2002 till October 2006. These appointments, which were made after 4/7/2005 in the instant batch of writ petitions, did not have SIU approval and also were made dehors the rules of 1997, which were required in view of the office memorandum dated 4/7/2005. Then, Lordship will come to para 90.
We would like to go through that analysis.
You like, Lordship will go to analysis.
Better to, para 72.
Lordships, para 72. The pivotal question, that's the issue, para 72.
Yes.
I'm grateful, Lordship. Actually, para 72, 74 is where our case is, the case of the, yes. The pivotal question which arises in the present batch of writ petition is as to whether the writ in the nature of certiorari can be issued in the present facts interfering with the removal orders. For the purpose of deciding the same, this court finds it relevant to note that except in cases of petitioners in writ petition so and so, that is us, there are no material particulars pleaded or material produced which would show that the petitioners in the remaining 11 writ petitions were appointed person to the selection process initiated. This court finds it apt to reiterate that in writ petition so and so and so, there are certain statements made to the effect that there was a valid selection process. However, as aforestated, there are neither any pleadings with material particulars nor any documents evidencing the same. Even the orders of appointment of the petitioners in these writ petitions do not disclose on what basis some selection procedure or select list the petitioners were appointed. Now coming to the cases, this is our cases being considered, 73 and 74. Now coming to the cases, that is writ petition 1931 and 8820, the pleadings as well the documents enclosed would show that some selection procedure was initiated. As already stated herein above, in respect to the petitioners in WPC 1931, there was an advertisement dated 4/12/2004 issued by the Joint Director of Health Services, Dibrugarh, for filling up a few vacant posts of grade 4 under the establishment of Joint Director of Health Services, Dibrugarh, and the Office of the Malaria Officer, Dibrugarh. There was no mention whatsoever in the said advertisement as to how many vacant posts were advertised. It is also not known as to whether the said advertisements was at all published in the Assam daily newspaper, Ahom Spandon, Dibrugarh, as well as to the office notice board. It, however, reveals from a perusal of the information furnished by the Joint Director Health Services, Dibrugarh, on 15/6/2021 under the RTI Act that on 17/2/2005, the Joint Director of Health Services Dibrugarh had issued a communication to the Director of Health Services, Assam Hengrabari, whereby the select list of candidates for recruitment to the post of grade 4 was forwarded. Very significant. From the said select list, it transpires that names of 47 candidates were mentioned in the said select list. The statement containing the marks by the candidates who applied for the post of grade 4 of the Joint Director of Health Services was also enclosed. From the said statement, it reveals that 103 candidates appeared in the final selection process. So this court further finds that it is relevant that the selection board consisted of SDM and HOHE, the additional CMO and HOFW Dibrugarh, and Joint Director of Health Services. This is with respect to Dibrugarh. Now, Goalpara. In respect to the selection procedure pertaining to WPC 8220 of 2019, it is seen that an advertisement was issued in the daily newspaper Ahomia Khabar on 3/1/2005 by the Joint Director of Health Services, Goalpara, whereby 70 posts of grade 4 under the establishment of Joint Director Health Services, Goalpara was advertised. From the records, it reveals that the select list was prepared of 75 candidates by the selection committee, consisting of the Joint Director of Health Services, Goalpara, and 2 others. The said select list was prepared on 5/2/2005. It is also noteworthy to take note that on 6/1/2022, one of the petitioners sought for information under the Right to Information Act 2005 regarding the government notification in relation to SIU, and since when the SIU for grade 4 employees had come into effect, and when any order with respect to SIU in grade 4 employees were received by the Office of the Joint Director of Health Services, Goalpara. The PIO and SDM and HOSH wide communication dated 23/5/2022 informed that the information as sought for was not received by the office.
What is this SIU?
This is Staff Inspection Unit. Actually, this is a unit which was constituted to see whether some post can be abolished, amalgamated for proper efficient functioning of the government, to recast the posts.
Staff inspection unit.
Subject to correction.
Yes.
Before further proceeding to adjudicate the pivotal question, this court finds it relevant to take note of as to whether the rules of 1997 would be applicable for selection of grade 4 employees in the health department of the government of Assam. Although the initial pleading, there is no mention as regards the applicability of the rules of 1997, either by the petitioners or the respondent health department, but in the additional affidavit dated filed on 31/5/2023, reference was made to the rules of 1997, which are required to be followed for selection and appointment of grade 3 and grade 4 posts of the districts in the Health and Family Welfare Department. This court has already, in the previous segments of the instant judgment, dealt with the rules of 1997. Rule 3 of the rules of 1997 stipulate the applicability of rule of 1997, taking into account the relevance of rule 3 of 9, the same is reproduced here under. I will just pause for a moment, Lordship. Lordship has seen the termination order. This is now traveling beyond the reasons given in termination order. The termination order never indicated that there was no compliance of 1997 rules. This is traveling far beyond the travel. This is something brought on record by an additional affidavit during the court proceedings. Lordship will kindly bear that in mind.
Termination order may not be, I mean, so elaborate, but they have simply said, detected that your appointments are fake, or whatever the procedure they have followed, that is fake. That's not.
But now it appears the foundation of our termination is non-compliance of the 97 rules, which again I will demonstrate that there is substantial compliance. There has been a selection, there has been an advertisement. The rules say there should be 4-member committee. Here there was a 3-member committee. Does it vitiate the whole process to an extent that you remove people after 15 years?
Yes.
Yes, I'll just continue. Now the rules are extracted. Para 76 is
the rules also.
Yes, rules.
Application.
Yes. These rules shall apply to only those class 3, both technical and non-technical, and class 4 posts, where there are no service rules, executive orders regulating the recruitment and conditions of service, and are not within the purview of the Commission. These rules shall not apply to the following cases. The post to which recruitments are made as per existing service rule and executive orders, the posts which are within the purview of the Commission, the post of teachers under Education Department, the post of police under the Home Department, the post of establishment of Raj Bhavan, Assam Legislative Assembly, High Court, Assam Public Service Commission, Lok Ayukta, and the post excluded from the purview of these rules by any general or special order by the government. From a perusal of Rule 3 of the rules of 1997, the same shall apply not only to those class 3 and class 4 posts, where there are no service rules, executive order regulating the recruitment and conditions of service, and are not within the purview of the Commission. Sub-rule 2 of Rule 3 specifically stipulates the cases where the said rules of 1997 would not apply. The learned counsel for the petitioners, however, has failed to show that there is any service rule, executive order regulating the recruitment and conditions of service of class 4 post in the Health and Family Welfare Department, Government of Assam. The petitioner further has failed to show that the class 4 posts of the Health and Family Welfare Department are excluded from the purview of the rules of 1997 by any general or special order by the government. Under such circumstances, it is the opinion of this court that the rules of 1997 duly apply to the selection of class 3 and class 4 posts of the Health and Family Welfare Department. It is reiterated once again that the rules of 1997 have come into effect
with effect from 4/8/1997. So this is the first finding that 97 rules apply to our appointments. In the backdrop of the above,
And that is not, you are also not disputing that. Yes, rules 1997 are applicable.
well, I will not
Your case is
straight away admit that the rules are applicable, but even if it is applicable, there has been a substantial compliance.
that's,
But I'm not straight away conceding that it applies.
then which rules applied for your, the governing your?
No, in fact, that is the precise argument we had raised. Till now, under the establishment, it was for a department to tell that prior to this, what were the rules applicable? They couldn't come and apprise the court. For the first time, they took up the stand. That is what my instructing counsel tells me. I was not before a single judge.
Yes.
Yes. May I continue? In the backdrop of the above, it would be seen that in 11 writ petitions, there is no whisper of any material particulars in the pleadings filed by the petitioners or any materials produced that there was any selection process initiated on the basis of rules of 1997, or for that matter, even as regards any selection as contemplated under law. However, in writ petitions so-and-so, though there are mention of initiation of selection process and the select list being prepared, the details of which this court has already mentioned herein above, but the said selection process initiated, the selection procedure as well as the select list so prepared are not in conformity with the rules of 1997. This court has arrived at the said conclusion on the basis of Rule 4 of the rules of 1997, which stipulate how the vacancies are to be advertised, what the selection committee is required to do in as much as the advertisement which has been mentioned in the writ petitions were not in accordance with Rule 4.2 of the rules of 1997. This court finds it relevant that from a perusal of the select list, which has been enclosed by the petitioners in writ petition so-and-so to the affidavits in reply, it is seen that the constitution of the selection committee was also not in accordance with Rule 5.1a of the rules of 1997, which stipulate composition of the selection committee to comprise of one appointing authority or the senior most departmental officer available in the district where the vacancies arises nominated by the appointing authority as the chairman, a departmental officer belonging to the office under which the vacancies arise as the member secretary, an officer in the rank of EAC up to SDO to be named by the deputy commissioner of the district where the vacancy arises as member, 4, an officer of the department other than the department under which the vacancy arises as a member, and 5, an officer of the department other than the department under which the vacancy arises and the department from which the deputy commissioner nominated. An officer as member of this committee to be named by the appointing authority as member. However, from a perusal of the select list enclosed to the affidavits in reply shows that the selection committee in respect to the selection of the petitioners in so and so comprised of 3 persons. The Joint Director of Health Services, Goalpara as chairman, SDM and HO Health, and the additional CMO and HO FF Goalpara. So instead of 5, there were 3. So he says, no, this is the selection committee itself is wrong.
Not as per rule 5.
Not as per rule 5. Same is also the composition of the selection committee in respect to the selection of the petitioners in WPC 1930/2020. This court further finds it relevant to take note of another aspect of the matter, in as much as in some cases it is seen that the Director of Health Services Assam had appointed some of the petitioners. There is no mention in the writ petition wherein the Director of Health Services had appointed such petitioners as to whether the same was done on the basis of some selection process initiated in terms of rules of 1997. Therefore, it would be seen that the appointments of the petitioners to the various grade 4 posts under Health Department were totally in violation of the rules of 1997. Be that as it may. Now, this is that argument when we say the learned single has traveled much beyond the reasons given for my termination. This is where he deals with that argument. And even the show cause notice, which I'll Lordship show, the final show cause, this was never indicated to us. I would appreciate that termination order may not indicate, but at least the show cause notice should have indicated. There were 2 High Court previous single judge orders saying that please inform the delinquent employees the exact deficiencies, the specific deficiencies in the show cause. There are 2 previous High Court single judge orders in this case itself.
In relation to these.
That please indicate the specific deficiencies that you are finding.
Yes.
Be that as it may, this court finds it relevant at this stage to take note of the submission made by the learned senior counsel for the petitioners that the impugned removal orders were issued on the ground that the same were not in conformity of the rules of 1997, or for that matter, the selection was not done in terms of the rules of 1997 as such. And as such, the learned senior counsel appearing on behalf of the petitioners placed reliance upon the judgment of Supreme Court in so and so, to the effect that public orders made by public authorities, which are meant to have public effect, are intended to affect the acting and conduct of those to whom they address and must be construed objectively with reference to the language used in the order itself. On the basis of said submission, the learned counsel for the petitioner submitted that the rules of 1997 were never in contemplation of the respondent authorities at the time of issuance of the impugned removal orders, and as such, the rules of 1997 cannot be imported now to justify action behind the impugned removal orders. This court is of the opinion that though the said submission at the first glance appears to be tenable, but taking into account the constant stand of the respondent authorities since the formation of the screening committee on 27/3/2017, I think so, it should be 2017, that the appointments of the petitioners were dehorsed the recruitment policy and were not genuine, the said submission of the learned counsel for the petitioners, in the opinion of this court, is misconceived, and more so when the rules of 1997 for selection of candidates in class 4 posts are applicable. It is also of the opinion of this court that when the issue has arisen as regards the genuineness of appointments of the petitioners are concerned, this court cannot shut its eyes to the stipulation of the rules of 1997, be that as it may, even dehorse the contentions that the rules of 1997 were not complied with. Let this court examine whether the proceedings initiated which culminated with the issuance of the impugned removal orders can be interfered in the present facts and circumstances. In the foregoing paragraph of the instant judgment, this court has in detail dealt with the materials on record. From the materials on record, it is seen that on the basis of the office memorandum dated 6/12/1999, the state-level empowered committee was constituted. It was specifically mentioned in the office memorandum that the existing vacant posts cannot be filled up by direct recruitment or promotion without the approval of the state-level empowered committee. It is also seen from the records that the office memorandum dated 6/12/1999 was brought to the notice of all concerned of the government of Assam by communication dated 7/12/2019 1999, issued by the Commissioner and Secretary of the Government of Assam Finance Department. Further to that, by WT message dated 22/12/1999, all deputy commissioners and subdivisional officers were also informed about the OM dated 6/12/1999. It is also seen that on 11/4/2002, the government in the Health and Family Welfare Department had directed the Director of Health Services as well as the Director of Health Services Family Welfare not to issue any appointment order via communication dated 11/4/2002. This very communication further stipulated that even in cases where permission of SLSC and the approval of the Minister, Health and Family Welfare Department was obtained, then also there should be no appointments. Their directions were also communicated to all joint directors of health services of the districts and additional directors of health services by communication dated 25/2/2002. There is, however, no record as to when the ban was lifted, but it has been mentioned in the additional affidavit dated filed on 31/5/2023 by the Director of Health Services Assam that for the first time, selection and appointment of 76 numbers of grade 3 and grade 4 posts under the Health and Family Welfare Department was conducted in October 2006. And the said drive was initiated pursuant to letter of the Health and Family Welfare Department number so-and-so dated 19/1/2006 as per approval of the Finance SIU Department dated 3/8/2006, mentioned in the letter dated 18/10/2006 issued by the Finance Budget Department. Under such circumstances, the question arises as to how the appointments were made prior to SLS's dissolution with effect from 36/2005 without the SLS permission, and also how during the ban period with effect from 11/4/2002 till 18/10/2006, any of the appointments made by the Joint Directors of Health Services of the concerned districts or the Director of Health Services Assam. From the above, therefore, not only is it seen that the rules of 1997 were not followed, but the appointments were made by the Joint Director of Health Services as well as the Director of Health Services Assam during the ban period, which was only lifted in the month of October 2006 when the approval was granted by the Finance SIU Department. This court further finds it relevant that the office memorandum was issued on 4/7/2005 by the Finance Department of the Government of Assam, wherein amongst others it was specifically stipulated that it is only upon the recommendations of the SIU the concerned administrative department will fill up posts as per rules and after observing all procedures. Therefore, post 4/7/2005, please mark this word, date, post 4/7/2005, without approval of the Finance SIU Department and without following the rules of 1997, no selection could have been filled up either by the Director of Health Services or the Joint Director of Health. I will just pause for a moment, Lordship, and just Lordship may make a small mark there. Our selection process began on 3/1/2005.
But appointments were all in August 2005?
True, but the selection
August or
process.
October.
Around
It is also relevant to take note of that the Act of 2005 was brought into effect from 1/9/2005, whereby no new post could be created without prior concurrence of the Finance Department. No appointment shall be made by the state government or the appointing authorities under it in the vacancies arising out of transfer and leave of incumbents to this post, and the appointment letters to the vacant post shall clearly indicate the identity of the post in the manner as prescribed. It is also relevant that the rigors of OM dated 4/7/2005 insofar as grade 4 post was never relaxed, and thereby the approval of the Finance Department was mandatory. Under such circumstances, it is difficult to visualize or accept as to how post 4/7/2005 any appointment could have been done without SIU approval and without following the rules of 1997, which is applicable. So he basically, Lord Singledas goes on this only, that there was no SIU approval and the appointments were dehorsed the 1997 rules. Essentially, these are two things that has been set as, because there is no allegation of any malpractice by us, any malafide by us, any fraud played by us.
So since 2005, since the appointment of the petitioner, they could draw the salary till 2019.
Absolutely. Through the treasury, regular salaries.
Then what meaning has SI approval have here? Government, this is a mechanism set up by the government. You are yourself violating it. And then you are terminating them. What kind of a standing?
How they have identified the posts which are this, as the Planet Single they observed that this rule 3. Rule 3,
Good Lordship, take up the rules.
these rules shall apply to those class of so and so, class 4 posts where such no service rules, executive order regulating the recruitment and condition of service are not within the purview of the commission.
That's the Assam Public Service Commission.
No service rule regulating the recruitment.
They were all appointed as
Grade 4.
grade 4, which post?
I will just touch it.
Grade 4 is not a post, it's a category.
Yes. Somewhere as a helper, somewhere as ward boy. But the appointment order, if Lordship will see, which is at page 167, it is says is hereby appointed temporarily as grade 4 and posted at Rongzuli PHC Goalpara.
And what is that? Till 2019, you were getting regular salary.
Yes.
What are the avenues of promotion, etc.? Nothing.
No problem.
Only class 4.
Yes, but
Whole lifetime. And increments, what about pensionary benefits, something?
pensionary benefits are available. Pensionary benefits are available.
These are against sanction posts,
Sanction post.
vacant sanction posts.
Vacant sanction post, that appointment letter says. Vacant, we have been appointed as a vacant sanction post. And Lordship will see there's an advertisement in a newspaper. How can it be fake? And these appointments were, the Director of Health Services was in the loop since 2005.
Appointment, the selection newspaper publication of newspaper. Is there any record how many persons have applied and
Yeah,
how many of-
103, the
how
single,
many of them have selected and
single there's notes it, 103 people participated in the.
process for selection, process of selection,
Yes,
interview or
interview.
only interview?
Written and interview both.
Next.
Written.
Interview? Interview, Lordship.
Only interview.
In fact, this advertisement, if for a moment, Lordship will see the advertisement, page 163.
Mr. Gogoi, has the state not accused, assuming that there was some deviation violation, has the state not accused to these appointments by paying them regular salary for such a long period
My
of
lord,
time?
only my lord in 2017, on these things came to the notice of the higher authority.
That's right.
While verifying the my lord, service records of the surveillance worker.
We understand, but ultimately,
Yes,
since 2005, they are regularly working.
what
Government is paying them regular salary.
lordship.
What is the, and ultimately, on what post you have appointed them?
In all my lord, grade 4 code, like
Grade 4
beyond, yes, sir.
collectors and everything.
No,
Specific post, any grade 4 post, if A is appointed or B is appointed, oh, and after 14 years of service.
What difference does it make whether 3-member board or 5-member?
And ultimately, no private person or any other person has raised any grievance regarding that appointment.
No, it was only in the my lord, screening my lord, test, my lord, where all the grade 5 employees, my lord, their services were verified.
Then, my lord, all these things came to light.
How many?
Except, my lord, these two,
How
my lord,
many how many persons were terminated
in hundreds, my lord. In every district, there was, my lord, we have found that, my lord, there are persons who are working without there having any selection, without there having any appointment, except these two districts, Dibrugarh and Gwalpara. Rest, my lord, there is no such selection. In fact, my lord, no appointment letter is there. Some have joined, my lord, with some transfer order coming from BTC. And they started getting salary here, and there is no service record in BTC that they have actually joined.
They started getting salary, then.
It's saying, my lord, somebody from BTC, my lord, he has joined in Jorhat. Only he has got the transfer order. In fact, in the writ petition also, they were.
Salary was paid to them by the government
Yes,
department.
my lord, they were getting the
So
salary.
have you not accused to the process? That's what we are asking you.
Yeah, but, my lord,
Unless there is a fraud by acquiescence,
yes, yes.
you can't
Otherwise,
now reopen this.
in fact, my lord,
So far as there,
in fact, my lord,
we have to go by some principle of law, is it not?
Lord,
So let us assume that the process was not done as per the mandate of a particular rule, etc., etc.
my lord.
Or let us say it was not completely transparent.
No, yes, read further.
Yes. One, no, Lordships. I was at para 80.
Para?
We were at para 83, Lordships.
Yeah. This
court further finds it relevant that the office memorandum was issued on 4/7/2005 by the Finance Department of Government of Assam, wherein amongst others it was specifically stipulated that it is only upon the recommendation of the SIU, the concerned administrative department would fill up the post as per rules and after observing all procedures. Therefore, post 4/7/2005, without the approval of the Finance SIU department, and without following the rules of 1997, no post could have been filled up either by the Director of Health Services or by the Joint Director of Health Services. It is also relevant to take note of the Act that of 2005 was brought into effect from 1/9/2005, whereby no new post could be created without prior concurrence of the Finance Department. No appointment shall be made by the state government or the appointing authorities under it in the vacancies arising out of transfer and leave of incumbent in this post, and the appointment letters to any vacant post shall be clearly indicate the identity of the post in the manner as may be prescribed. It is also relevant that the rigors of OM dated 4/7/2005, insofar as the grade 4 post was never relaxed and thereby the approval of the Finance SIU department was mandatory. Under such circumstances, it is difficult to visualize or accept as to how post 4/7/2005 any appointment could have been made without the SIU approval and without following the rules of 1997, which was applicable. The illegalities so committed by the officials of the health department are manifested in each of the appointments made by them. Let this court take the cases of the writ petitioners in WPC so and so. This is not me, Lordship. So I will just skip this because this is not my case. This is Morigaon. Thereafter, it comes to North Lakhimpur, para 85. Then thereafter, 86 is Gwalpara, but not the Gwalpara batch that I am representing. Then 87 is with respect to Porbatia Sub-Center. Now para 88. Therefore, from the above analysis, it would be seen that all the appointments which were made favoring the petitioners in the instant batch of petitioners, writ petitioners dehorsed the rules of 1997. The appointments so made on 2/36/2005 not only did not have the SLEC permission, but were also made during the ban period, which was in existence from 1/4/2002 to 2006. The appointments which were made after 4/7/2005 in the instant batch of writ petitions did not have SIU approval and also were made dehors the rules of 1997, which were required in view of the office memorandum dated 4/7/2005. This court at this stage finds it relevant to take note of the judgment of the Supreme Court in case of State of Bihar versus Devendra Sharma reported in so and so. when the Supreme Court was dealing with the termination of large number of candidates who were appointed against class 3 and class 4 posts in the Health Department of the state of Bihar in paragraph 35 to 44, the Supreme Court, by taking into account the various judgment or the opinion that no interference can be made to the termination orders. Shall I read this paragraph or can I?
No, in the Bihar judgment, it was a false fraudulent.
Yes, fraudulent. There's no allegation here. Then Lordship will come straight to para 90 with page 1506. From the above analysis, 1506 para 90. From the above analysis of the facts and the relevant provisions of the law, it would be seen that the Health Department of the Government of Assam had carried out a detailed fact-finding inquiry as regards the genuineness of the appointments of the petitioners. The petitioners have been afforded the opportunity to appear before the screening committee on various occasions, and the petitioners have been asked to prove the genuineness of the appointments. Not only the petitioners failed before the screening committee to prove the genuineness in spite of deficiencies pointed out, even before this court, the petitioners could not show that the appointments were made in terms of the provisions of rules of 1997 or were made with the approval of the existing SLEC, or that their appointments were made not during the ban period, or that there was finance SIU department's approval prior to their appointments. The only plea which has been taken in the replies to the show cause notice was that the petitioners were duly appointed against vacant sanctioned posts and were regularly receiving salaries without any objection, and the transfer orders of the petitioners or petitioners were appointed. It was also the argument of the learned counsel for the petitioners that by drawing attention to this court, to the OM dated 4/7/2005 and 14/7/2005, that the petitioners being disbursed the salaries by the respondent authorities meant that the petitioners' appointments were either made with due approval of the SLEC or with the approval of the Finance Department SIU, in as much as without approval number, the salaries of the petitioners could not have been released. That is our whole case. It is the opinion of the court that the said contention of the petitioners are totally misconceived, inasmuch as if the appointments of the petitioners were made divorce the rules of 1997 or during the ban period or without SLEC or SIU approval, as the case may be, the illegality in their appointments do not get legalized in view of the complicity of the then Joint Director of the Health Services, Director Health Service Assam, and the Treasury officers who were releasing their salaries with impunity, resorted to illegalities, nepotism, favoritism by violating the provisions of rules of 1997, the prevailing executive instructions, as well as the rights of other eligible candidates under Article 14 and 16 of the Constitution. It is nobody's case that there was favoritism, that there was nepotism.
Is there any allegation of nepotism here?
No.
In the, yes, no.
No, please take it from me. No favoritism, no nepotism, and no other candidates are challenged.
Any relative, son, daughter of the Joint Director of the.
Nothing, no breeding. And he says, we have denied the rights of other eligible candidates. There are no eligible candidates who have come and challenged us. These are all beyond everything, the records of the case.
When you say he, you mean the learned single judge?
No.
Then?
The learned single judge.
No, when you are referring to he in your argument, are you referring to the learned single judge?
No, I apologize. If I made that, I'm extremely sorry. I've taken that.
Just thought.
I'm extremely sorry. That was never intention. So the learned single judge, perhaps this was not never part of the record. It was no one's case that there was any favoritism or nepotism. It was only on the violation of the rules. As Lordship has seen the thread of the judgment, it was only violation of the 1997 rules. So therefore, the final directions that the court passes at para 93.
Yeah.
Accordingly, this court therefore directs as follows. The government officials who were responsible in facilitating such illegal appointments and the government officials who resorted to pay salaries to the petitioners without taking into account as to whether the petitioners' appointments had SLEC or SIU approval are required to be made accountable, as they have resorted to actions which have resulted in breaking the public trust reposed upon them. A constitutional duty is cast upon the state, therefore, to take action against such officials who have belied the trust of the government. This court therefore directs the Chief Secretary of the Government of Assam to initiate appropriate actions against such officials as per extant laws, including the criminal actions. This direction is issued to the Chief Secretary, Government of Assam, taking into account that during the course of hearing, this court made a specific query upon the learned standing counsel appearing on behalf of the health department as regards any criminal proceeding initiated against them, and the then officials to which the learned standing counsel health department submitted that certain criminal proceedings have been initiated, but the same are not progressing as required due to indifference of some departments. Therefore, this court, deeming it fit and proper, has issued the above directions to the Chief Secretary, Government of Assam. In view of the above analysis, this court has not interfered with the impugned orders of removal. Consequently, in view of the removal of the petitioners from the vacant sanction post, himself, Lordship, the court itself recognizes vacant sanction posts, the government may take appropriate steps for further fresh recruitment. It is the opinion of this court that if any recruitment process initiated in respect of those posts, the petitioners would be at liberty to apply for such posts. This court directs the health department of the government of Assam to relax and or condone the age of the petitioners in the instant batch of writ petitions if they apply to the fresh recruitment process. Taking into account the petitioners have already rendered the services for which the petitioners have received salaries, the respondent health department shall not initiate any recovery proceedings from the petitioners in view of holding that the appointments of the petitioners were illegal and non-honest by this court. With the above observed, the instant petition stands disposed of.
Whose prayer was it to initiate inquiry, etc.? Against the hiring official?
Well, that, my lord, the honorable court made the observation. Finally,
What steps you have taken after that?
my lord, in fact, my lord, the Chief Secretary has already directed the health department to look into the particular issue and to, my lord, find out who are those
So
officials.
how many officers are there? Some might have retired, some might have
Already
expired.
expired, my lord, by it, because these are of 2005 and prior to 2005. But, my lord, they are doing it, my lord, they have sought for some details from the district authority, and it is under process. In fact, some meetings have also been held, my lord, in this regard for compliance of this part of the order. And my lord, one thing I'd like to point out, my lord, except in the district of Gwalpara and Dibrugarh, there is no such record being placed by the writ petitioner before the learned single bench that, my lord, they were appointed pursuant to some
Single
selection.
judge has already noted.
Yes. In
But
fact, my lord, in
the
item
thing
number,
is- The thing is, there was no record, nothing. Still, those people were continued with you years together. You are paying them salary, you are paying them all the benefits. You are taking work from them also.
but they are not before his honorable court challenging the order. Probably, my lord, they are aware that they are paying appointed, my lord. So they have chosen not to, my lord.
In this batch, only Gwalpara and Dibrugarh.
No, my lord, total, my lord, there were 13 or 14 writ petitions, my lord. Two writ petitions pertaining to Gwalpara and Dibrugarh, where they have got the records of
All
selection.
those petitions have been decided or what?
All, but in the same order.
How about two in Gwalpara and this another district
Yes,
and
yes, same writ petitioners, now, my lord, they have divided while filing the writ appeal. In otherwise, my lord, two writ petitions were there, my lord, of two separate districts. Now they've got, my lord, separated while preferring the appeal. Yes. Otherwise, there was only two writ petitions.
47.
And, my lord, the last one, that is, my lord, item number 48. They were, my lord, appointed for 1 month, somewhere 3 months, subsequently regularized without any approval from the government. Yes.
Let me allow to ask that.
No, that's I'm pointing out. It's not the similar as, my lord, Gwalpara and Dibrugarh. It today before this honorable court. 48. 45, 46, and 47 are from Gwalpara and Dibrugarh. But, my lord, one thing I think.
Just a minute. Mr. Goswami, your clients are still working.
No, they've been terminated in two
There
thousand
is no
nine.
stay order.
Now there is a order from the division bench saying that the appointments may not be, the post may not be filled up.
As a filled up.
May not be filled up. The posts are vacant, Lordships. In fact, 34 posts. In fact, Lordship will just appreciate another aspect of the angle of the matter. 2019, these people were terminated. 2020, COVID hit in. They had no people. So these people were drafted in to be the first warriors, the first responders. Without salary, they did that service.
Don't try to.
Hey, I'm just telling you that whenever the state wants a
There are
service.
many people who have volunteered their services in the COVID period. But,
19 they were terminated.
Yes, but despite that, because you didn't have skilled people.
That's the law.
So that's insofar as Gwalpara is concerned.
Gwalpara and Dibrugarh. This is, I am representing 17 petitioners in each of the cases. So I am representing 34 people.
Facts are similar.
Facts are similar in both. They also agree to that, that facts are similar with respect to Dibrugarh and Gwalpara.
Remaining, how many persons are there?
How many?
13 petitions are filed. 13 petitions are filed. Out of this, petitions the one category. And another L1 in the,
In the another category, how many persons are there?
in my case, there were 96.
96
96.
in all those other category persons.
So for the Steve Sagar district, 96. Another maybe another 50, 30, like I think 47 has 20 petitions for
You prepare a chart. Or you want us to.
Total employees involved are?
150, all at close to the 170.
In this present batch of lead appeals, madam.
Read appeal.
34 plus.
Now it is.
170. Around 170, 175 total.
170, 175.
Facts are similar.
No, madam, not similar. But so far as my learned friends is
The
concerned,
Dibrugarh and this Gwalpara are somewhat different and other.
yes, madam.
Slightly. I will.
So in your case, no advertisement, nothing.
In my
But
case, regularized.
You continued and your services were regularized. On the basis of that, you are claiming the services are regularized therefore.
Yeah, Mr. You're Mr. See, you have one obstacle which you have to satisfy the court, because we are going to examine the matter from the touchstone of rights, if any, accruing to the petitioners under Article 14 and 16. We are not concerned about who has done what, etc. Or what is the remedial measure. That is none of the concern of the court. The law is well settled that regularization is not a mode of recruitment. Are you aware of that?
Yes, sir.
So how do you overcome that in your case?
Lord, I am relying upon quick judgment, Honorable Supreme Court. And according to that, the Supreme Court has basically held that once you render the services for a considerable time and throw them out of on the ground that there was no approval for their recruitment, then obviously it is nothing but a pressurize or harassment of that employees. I'm relying upon these two judgments.
Employees, you are in fact, technically speaking, you are not even employees.
My lord.
You are not even employees, technically speaking. No appointment, nothing.
No, appointment.
Simply on the basis of transfer orders and.
No. Appointment is there. Kindly allow
Okay,
me to-
we'll hear later on. Yes, Mr.
Yes.
Any law point in your
Yes,
favor?
so having seen the facts, Lordship, I have just, my written submissions, I'll just go through it briefly and place the judgments that I'm preferring. For Lordship's convenience. May I just place my written submission? My first slip of submission, the appointments of the appellants can at best be termed as irregular and not illegal. In the present case, substantial compliance with the constitutional stream, as also the rules have been made that we have demonstrated. The appointments of the appellants can at best be held to be irregular. It is certainly not illegal. The alleged irregularities, as pointed out by the learned single judge as para 77 of the impugned judgment, do not have any relevance for the assessment of merits of the candidates who were appointed. It is not the state's case that the appellants were eligible for appointment. Hence, the learned single judge was wrong to quash the appointments of the appellants herein.
Okay.
Under the same heading is on the SIU approval also, I have said that as regards the second issue regarding SIU approval, it is submitted in the office memorandum bearing number so-and-so dated 4/7/2005, issued by the government of Assam Finance Budget Department clearly states that the requirement of SIU approval was given effect from 21/7/2005. The aforesaid OM was not in existence at the time the selection process commenced, which is 3/1/2005, that is the date of advertisement. Hence the same cannot be retrospectively applied to the disadvantage of the appellants. Alternatively, it is submitted that the very fact that the appellants have been drawing their regular salaries for 14 long years would in itself indicate that there was a deemed approval by SIU. It is not the respondent's case that the SIU has at any point of time opined that the posts to which the appellants were appointed are not required and to be abolished. Under the same heading, the appointments made by the joint director is legal and sustainable. He is the appointing authority as contemplated within the meaning of section 2A of the Assam Public Service Direct Recruitment of Class 3 and Class 4 Post Rules 1997. There is no specific rule indicating that the advertisement cannot be issued by the Joint Director of Health Services and or the authority who is authorized to issue advertisement. And as such, the advertisement so issued by the Joint Director Services cannot be termed to be unauthorized. This condition is fortified by the following crucial circumstances. So these documents Lordship has gone into. Now, what is irregular and illegal has been there are several judgments on that, but I'll just place one, Lordships. That is, Lordship will kindly take up 2020-19 SCC 480 Siraj Ahmed. This is a 3-judge bench judgment of the Supreme Court.
Para 10 to 16.
Yes, Lordship, para 10 to 16. Lordship, can have it. In fact, this judgment relies on ML Kesari, which I have also indicated, so I will not read ML Kesari. It extracts what ML Kesari says. May I come straight to para 10, Lordships, at page 483.
Yes.
The facts in the present case are not in dispute. Undisputedly, the appellant's initial appointment in the year 1987 was after the advertisement was issued for the post in centralized services constituted under the said rules. It is also not in dispute that the appellant was selected after he underwent an entire selection process by competing with other persons who also applied for the said post. The only issue that the learned single judge of the division bench have found against the appellant is that the appellant's selection was not made in due consultation with the UP Public Service Commission. Same like us, lordships. This court in state of MP versus so-and-so, after considering the judgment of the Constitution bench in state of Karnataka versus Uma Devi, observed thus. The question which thus arises for consideration would be, is there any distinction between irregular appointment and illegal appointment? The distinction between the two terms is apparent. In the event the appointment is made in total disregard of the constitutional scheme as also the recruitment rules framed by the employer, which is state within the meaning of Article 2 of the Constitution, the recruitment would be illegal one. Whereas there may be cases where although substantial compliance with the constitutional scheme, as also the rules have been made, the appointment may be irregular in the sense that some provisions of the rules might not have been strictly adhered to. It can thus be seen that this court has held that the distinction between irregular appointment and illegal appointment is clear. It has been held that in the event appointment is made in total disregard to the constitutional scheme and the recruitment rules framed by the employer, where the employer is a state within the meaning of Article 12 of the Constitution of India, the recruitment will be illegal one. It has, however, been held that where, although substantial compliance with the constitutional scheme, as also the rules have been made, the appointment would become irregular in as much as some provisions of the rules have been adhered to. Subsequently, another bench of this court in state of Karnataka versus AML Kesari has also had the occasion to consider the issue. The court observed thus, it is evident from the above that there is an exception to the general principle against regularization enunciated in Uma Devi if the following conditions are fulfilled. The employee concerned should have been worked for 10 years or more in duly sanctioned post without the benefit or protection of the interim order of any court or tribunal. In other words, the state government or its instrumentality should have employed the employee and continued him with service voluntarily and continuously for more than 10 years. The appointment of such an employee should not be illegal, even if irregular. Where the appointments were not made or continued against sanctioned post, or where the persons appointed do not possess the prescribed minimum qualifications, the appointments will be considered to be illegal. But where the persons employed possess the prescribed qualifications and was working in sanctioned post, but has been selected without undergoing the process of open competitive selection, such appointments are considered to be irregular. This court held in ML Kesari's case that where the appointments are not made or continued against sanctioned post, or where the persons appointed do not possess the prescribed minimum qualifications, the appointment will be considered to be illegal. However, when the persons employed possessed the prescribed qualifications and is working against the sanctioned post, but had been selected without undergoing the process of open competitive selection, such appointments are considered to be irregular. As already discussed herein above, the appellants herein had applied in persons to an advertisement issued by the state for the post in the centralized services under the provisions of the state rules. The appellants had participated in the selection process along with the other competitors. The appellants were possessing the requisite qualifications.
That's what doesn't have anything.
Undisputedly, the appellant thereafter has continuously rendered his services till the date of regulation of his service on so and so, and even thereafter till then. As such, the appellant's case would be on a much better pedestal than the one which falls for consideration ML Kesari. And thereafter it says it can thus be seen that the only issue which is found against the appellant is that prior to appointment, there was no concurrence of the UP Public Service Commission. It can thus be seen that the appointment of the appellant at the most can be termed as irregular and not illegal. That is the view of the court in this case, lordships. Now, I will not read ML Kesari, though I have suggested because they have extracted what ML says. Now, lordships, the next limb of my argument.
The views in this Siraj Ahmed flows from Uma Devi and ML Kesari both.
Yes,
both have been merged.
yes, lordships. It has been good. Now, lordships, as lordships have seen from my argument and as fallen from the bench, if lordship will kindly come to my third submission, that is at the next page. No fault can be attributed to the appellants in the matter of their appointments. There is no allegation of any wrongdoing or unfair practice or fraudulent activity committed by any of the candidates appellants, and as such the said selection was not vitiated by malpractice. There are no allegations of any malafide either. It is also to be noted that there is no challenge by any unsuccessful candidate alleging corrupt practice and fraudulent activity resorted to by the appellants. The appellants have been serving for almost 14 years until their services were terminated in 2019. They've been drawing regular salary ever since the initial appointment without any break. This in itself is a strong factor indicative of the fact that the appointments were above board. To remove them from service at this stage of their lives will cause immense financial and emotional hardships to them. In this regard, it is submitted that Rule 14 of the 97 rules empower the state to relax the stipulations of the rules in appropriate case. This is one such appropriate case. That is, of course, for the state to respond to that. In respect of these submissions, lordship, I will rely on the first two judgments. Will kindly, lordship, take up 2013, because in such a situation, how has the court dealt with it?
This relaxation part you can't claim.
No, I am saying it is for them, if they are magnanimous.
Continuation of service relaxation at the time of recruitment, yes, certainly relaxation can be granted.
Because in the facts and circumstances, I am appealing to their magnanimity more than anything else. Lordship will kindly take up 2013.
Rather, possibly you could have taken the stand that because there is no allegation of wrongdoing, any malfeasance, so Devendra Sharma would not be applicable in this.
Yes, that's precisely what
That's the point you have.
we are taking the ground here now. It's 2000.
There in the argument. In the written submission, that ground is not.
This is what the day.
Devendra Sharma,
Devendra Sharma precisely may not apply. I'm grateful for lordship's pointing out it. If lordship will see 2013-14 SCC first. In such circumstances, how has the court dealt with it? That 2013-14 SCC 494 Vikas Pratap Singh. These are cases where the appellants there were no allegations of any wrongdoing by the appellants. Even then, their services were terminated. Would lordships kindly come to para 21 of this judgment at page 502. I will read from para 21 to 23. Sri Rao, just not for a moment, lordship, Sri Rao was my senior, PP Rao. I worked under his chambers in the Supreme Court.
You should read my senior Sri Rao.
That is, I wanted to indicate. I was lucky to work under him in Delhi. Sri Rao would submit that the case of these appellants requires sympathetic consideration by this court. Since the appointment of the appellants on the basis of a properly conducted competitive examination cannot be said to have been affected by any malpractice or extraneous considerations or misrepresentation on their part, the ouster of 26 appellants from service, after having successfully undergone training and serving the respondent state for more than 3 years now, would cause undue hardship to them and ruin their lives and careers. He would further submit that an irretrievable loss in terms of life and livelihood would be caused to 8 appellants amongst them who have now become overaged and would have also lost the opportunity to appear in the subsequent examination. Now, lordship will directly.
Right, Mr. Goswami, we'll go through the arguments, written submission.
I'm so grateful, Lorships. Lordship will kindly see this 2024 2SCC.
We'll go through it.
Yes. That's in respect of judicial service, but there was no advertisement in.
It's the analogy.
Yes, the analogy. Lordship. I'm so grateful. And Lordship will take it to there are posts available.
So, Mr. Goswami, we would appreciate if both of you could give us a chart showing in which cases, how many petitioners, which are
We will
the
do that.
cases,
We will do
what are the main allegations, whatever the government has come up. We would give that in a
summary.
tabular summary.
Summary along with the chart,
Lord,
in the
actually,
form of chart.
my lord, actually, the respondent government has not categorically given any reason to remove the persons. The one reason is there that your documents are not genuine. This is the only one reason for other.
Actually,
We will give
documents are
voluntary.
genuine is not the actual case. You are fake. This is what the reason they have given.
Yes.
But
give.
essentially, what they would mean that your appointments were not in accordance with law.
No.
Or
We will give that specific reasons.
that is what the.
We will give it. in chart.
So your principal argument is that
My lord, my case is slightly different. I'm adopting the entire argument raised by my senior colleague, my lord. My case is altogether similar to his case also, because in my case, my lord, the appointments were made during the period of 2004 and 2005, much prior to that cutoff date, which is the 4th July 2005.
that SIU requirement.
SIU requirement is there. My lord, thereafter, in my case, my lord, 86 petitioners employees were continued considerably for up to the year 1920. They were regularly paid salaries, and during the period of 2010 and 2011, they were regularized on that post. My lord, no allegation of favoritism and nepotism so far my case is concerned. The only difference between me and the case of Goswami is that in his case, there was an advertisement
And in your
selection.
case, there is no advertisement.
My lord, in my case, few of the petitioners were continued in service since the year 1999. There was a flood situation in state of Assam in the year 1999. So there was nobody ready to go to health department and serve for the affected persons due to that flood. So few of the petitioners were voluntarily approached to the department. They rendered their services in that flood situation, and they were continued as a casual employees in the department. Intermediately, they were called, they were stopped. But anyway, looking to their service, they were given an appointment on a vacant permanent post during the year 2004 and 2005. This appointment was continued till the year 2010 and 2011. In the year 2011, all these 86 employees were regularized. There is a specific order passed by the joint director of the health department that you have been regularized on the vacant permanent post. So from the year 2011.
The 86 persons got regularized on the very single day?
No, on some other dates, my lord. I have prepared a chart which shows the date of appointment and date of regularization. So I will these appellants before your lordship. So all these are during 2004 and 2005. Regularization is 2010 and 2011.
There is no dispute about the fact that your appointment was against the sanction posts?
Vacant sanction post.
Vacant sanction.
There is no dispute about that. So the regular salaries were made, and randomly this removal order saying that your documents are not genuine, and so they were removed from the services. That is this license different than my case and the Goswami's case, my lord.
In your case, the termination order is?
Of 20, the termination order is the same, my lord.
Same order.
Same order. It was actually published in the newspaper that all these persons have been removed. Randomly, there is 2-3 lines. The fake word is actually not used in my case, my lord. Page 922, if your lordship kindly come to page 922. 48. Pradeep Goyal. Page 922 is my removal order.
Page
922. May I read 922, madam? 25th February 2020.
So the same order is there.
Same order is there.
So there is the question of reading.
Same order.
Same order.
My lord, kindly come to the appointments of order and orders of regularization, my lord. Order of appointment, I'm sorry.
Yeah. Order of appointment.
My lord. Page 265,
Mr. You're an outstation counsel.
my lord.
You're coming from
Delhi, my lord.
Delhi.
Practicing before Honorable Supreme Court. Advocate on record.
So it's a all Delhi affair.
We got an opportunity.
I'm 50% here.
Page 265.
What do you mean by 50%?
This is my parent bar.
Oh, that's right, but what do you mean by 50%?
100%.
Yes, Mr. Goswami is from God.
Yes.
Page
Continue with the membership of the.
Yes.
Page 265, my lord.
Yeah, 265.
265, 7th February 2005. In continuation of this letter, number 3715-25.
From 561.
Dated 3rd July 2001, the following workers who has been working as casual basic are hereby appointed as grade 4 in the scale of pay rupees 2,450 to 3,670 per month plus and other allowances are admissible under rules for period of 3 months against the vacant post. So these are the few. Thereafter kindly come to page 268. 268 is very crucial. This is 18th June 1999. My lord, these appointments order are placed as they were in the writ petition.
It is in relation to one.
No, there are so many persons therein. The page 268.
Yeah.
Mail dated Sivsagar, the 18th June 1999. In view of flood situation, the following persons are alleged to work as grade 4 workers on casual basis against the institution. This is a typed copy.
The following persons are alleged.
My lord, this is a typed copy. Therefore, my lord, this is alleged word is mistaken.
Translated type copy.
No, typed copy only. The original copy is on the next page. 269. And so there is a deemed page allowed to work.
Allowed to work.
Allowed.
Yeah, alleged to work.
Allowed. Well, this is.
Following
Be clear,
persons are
my lord.
allowed to work.
Allowed to work.
Alleged to work.
And page 272 is one example. Page 72, my lord, where there is a order of regularization.
6 of year.
of the year 2011. Dated Shiv Sagar, the 5th, 2011. The order, services of the following grade for employees are hereby regularized with effect from inception of their services against the existing vacant post. The number is there, initial order number is there, and the year which is mentioned, the government sanction number, is the year when the post was sanctioned. So I have checked personally, so far.
Mr.
Atul Baba Center,
You have to give us a proper chart.
my lord.
Which page number, who are the petitioners, how many petitioners?
And their
Allegations.
appointment orders,
Even the volumes are not marked, volume 1, volume 2, nothing.
my lord, I will.
Give us some help.
By the next week, Tuesday,
My lord.
you, both of you, and yes, Mr. What are your?
So for that, my lord, one more case is there with that.
Some submission from my side, my lord.
Same submission. We are not going to hear you. You are appearing for the state in many of the cases, and now here you appear for the petitioner. Here now.
But I appear for the education department only.
The department is different, okay.
Lordship, for this, my name is wrongly reflected. It should be H. Amit Ahmed.
Should be
H. Ahmed. H.
Ahmed.
What is reflected?
M. Ahmed.
M. Ahmed. Ahmed is the same.
Ahmed is the same. M is different.
I'm great.
Next Tuesday, you also submit your whatever then details.
Instead of Tuesday, can it be on 14, my lord?
Huh?
For our part, my lord, 14th.
Why?
Same week, my lord.
Why?
Actually, on that day, the AG will be present, my lord. I would like to take his assistance. At least, my lord, this contractual part is concerned, my lord. Rest, my lord, yes. Walpara and Dibrugarh, of course, my lord, some judgments to place. And I will also refer to the rules and my lord, additional
The judgment of the Honorable Supreme Court, which Mr. Goswami has referred to.
I will definitely.
That also covered their cases also.
There are so many
Since
other.
the appointment are irregular. The appointments were against a sanctioned post. And the persons are having qualification, having requisite qualification, then those appointments can't be treated as illegal. Yes, the process was not followed on the competitive examination. They have not faced the competitive examination or whatever the process for competitive appointment. That is enough. That case is also, that judgment also covers their case also.
On
So far as
14,
prima facie opinion, subject to whatever you say.
on 14, my lord, will try. So same week, my
People are
lord.
going to go after
14th, I am having.
1998, 99. They have families, they might have, where are they going to go now?
Even in a little bit on 14, my lord. Our
Well,
part.
I'm having difficulty on 14th, well, let it be 12.
No, our part is concerned, because the state is concerned, my lord.
We'll see if necessary.
On Tuesday, Mr. Sekya is here now.
No, man.
No.
No.
We here on 12th, he will be returning by 12 evening. Our part, we can make it on 13th or 14th. At least let them complete, my lord.
13th
13th Thursday.
13th.
13th Thursday, you complete your arrangements. In fact, we have concluded the hearing for that only. For the details, we are.
I am obliged, sir.
Please give a case number wise, sir, so that we can identify whose argument is which one.
This one, 13th of June as started. For hearing.
I'm good.
For hearing. List for hearing on so and so started back.
And also address the court whether having appeared for the education department, whether you can.
Yeah, that is the important, very important.
That would be a disqualification for your clients.
Disqualification for client and may invite a use cost for that also on advocate.
If it is done like that.
That is there, that is there. You can't take benefit of both the private and the government. Can't take that.